You can turn that way down. I'll probably say maybe about 50, but you can just have somebody talk free right now. And then
can somebody from Zoom give me a microphone check, please?
Sonia, did you hear that?
I didn't hear anything. I mean, I heard somebody say, do a microphone check, please, but that was it.
you ask her how the microphone sounded.
How did the microphone check sounded? Was it very low?
I didn't hear anything. I didn't know anybody spoke.
Get ready.
Yeah. Yes, sir. Could you on Zoom? Zoom. Have you clicked in for Zoom?
Oh, yeah, I drove.
Oh.
Christy, can you talk in your mic?
He asked Sonia how did she hear that?
Sonia, can you hear me?
Yeah, I heard his question. I heard somebody say something, but I don't know what they said.
1, 2, 3. Test. 1, 2, 3.
Did you hear Christy do a test, Sonia?
No.
Carla, are you hearing any tests from Christy?
No. I didn't know she was talking.
That's the speaker.
Her thing is muted. A little bit.
Do it again.
Testing 1, 2, 3. Testing 1, 2, 3.
Yes. That's perfect.
Wait, the reason why she could hear you is because you had this selected. So this is the USB microphone, so you need to just keep it on the Realtek microphone. Okay. And then they should be able to hear everyone in the room.
Chairman Isikoff. I was told that Commissioner Waddell was going to be absent. Commissioner Scott advised that he would be 45 minutes late. So the meeting is being recorded. Ready for you.
And we do have a quorum here, so we can get started. Welcome, everyone, both everyone who's here in person and everyone virtually. This is the July meeting of the it's showing the red light. Can you all hear me?
Stretch it a little more towards you.
He was perfect.
Is that
Good
better?
for you? Okay.
Wonderful. Welcome, everyone. This is the July meeting of the Minimum Housing Standards Commission. We are concerned with housing code violations that inspectors have found at the properties that are on today's docket. What we're going to be looking for is a plan to correct the violations that the inspectors have found. Cases will be called, and we're looking for detailed plans, not just I'm going to fix it, but these are the contractors I've hired, these are the timeframes, this is where the funding is coming from for it. We're looking for specifics of a plan, and we're concerned with everything above the ground. So everything pertaining to structures that are on the properties that we're addressing. Just a couple administrative items. especially since we're doing partial virtual meetings. If anyone can turn off anything that's gonna buzz or chirp or ring or anything like that, especially virtual meeting, it's really important that we have clear communication and we can hear everyone. We will proceed with a couple administrative items, then we'll move into the docket, and then I understand we have possibly some other items to discuss after we go through the cases on the docket. First on our agenda, commissioners, you should have received minutes from last month's meeting. Are there any motions about that?
I motion to accept the minutes as presented.
Is there a second?
Second.
All right, all those in favor?
Aye.
I'm assuming that I should abstain since I wasn't here.
I think that's fair.
I did read what I could of your amazing minutes, of your amazing the manuscript, but a lot of it was not clear,
Mhm.
so I'm not comfortable.
So noting 4 in favor and 1 abstention, that motion passes. The minutes from last month's meeting are approved. Staff, are there any changes to today's agenda?
Yes, sir. The two appealed cases, items number 5 and 6, we are asking if to continue those until September, the September meeting.
Why?
Is there a reason for that?
Yes, the commission at the last month's meeting had requested the initial continuance for the purposes of discussing with the interim director a possible revision or change to the reduction policy.
Mhm.
September would allow us that time. We've been in discussion, and interim director Cynthia Blue is present with us today. So we have been in
Welcome.
discussion with them and the city attorney's office. We're not certain we can have a policy change by the August meeting, so we are asking for September. And we believe that any such change to the policy might directly affect those cases.
Thank you. So seeing that, I'll make a motion to continue those 2 cases, docket items 5 and 6 till September. We would hear them today.
The reason why I'm saying something is we didn't get past the appealed cases last meeting, and we did not uphold the inspector on those appealed cases. So the question is, on these appealed cases, will we have had to watch the video for priorly? And is there enough evidence, as we've just been told, that the evidence has to show that there's subsist, can you hear me? Mhm. Okay.
We can hear you.
So basically, we're looking at if we can hone out our policies and procedures. We'll hear
Gotcha.
these at a later date. I think, is that, Mr. Powell, is that accurate?
That is correct.
Okay,
And part of some of the discussion that I believe the interim director would like to add to your agenda today might kind of reveal what that future policy might look like.
absolutely. So my motion stands to, per staff request, continue those 2 cases till September.
I'll second it.
Any further discussion? Seeing none, all those in favor?
Aye.
Aye. That passes unanimously, so those are continued to September 9th.
And Mr. Chairman, since you're still on making adjustments to the agenda before approval, the interim director would like to add an item to the agenda.
Absolutely. Wonderful. And I know
We did
Ms.
not
Furman-
hear her.
commissioners have raised issues about wanting to discuss policies and procedures. So perhaps as an administrative item at the end of the docket, after we hear today's cases, we can have a general discussion about policies and procedures for the Housing Commission. So I'll add that to the end.
So we'll make a note, staff online did let us know that, Cindy, your comments were not heard. I think that for that button there, if you would, let's do a test. Push it and let the white light come on. All right, if you do a test for us.
Testing, testing.
Oh, did that not come through?
Did you hear that?
Heard that.
Okay, so for the record, we don't have what the director just said. Would you like to repeat that for the recorded record?
I'm asking the chair's permission to have a discussion at the end of the order of business in order to discuss potential changes to policy and practices with the Minimum Housing Standards Commission, as well as the Assistant City Attorney would like to discuss the memo that he presented resolving some of the questions that were asked for legal issues.
And I believe that's appropriate, so we'll add that to the end of today's docket. Are there any other changes to today's docket? Seeing none, I see we have a pretty light docket today. So with the 2 appealed cases being continued, first let's get city staff sworn in, and then we'll do any members of the public that are here, but it might make more sense, given that we're partially virtual, to do it case by case. So let's start with staff.
Okay. Do each of you swear or affirm the testimony you give in the following matters will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you. And we'll swear in owners and anyone else wanting to speak on properties as the cases come up. Moving on, docket item 7 is a withdrawal, 1014 East Side Drive. Commissioners, are there any motions on that? So my understanding is a withdrawal would be due to a repair.
I'd like
That
to
is
make a
correct.
motion that we accept that. I'm sorry, I'm seconding your motion.
I guess, yeah, I'll make a motion to withdraw docket item 7 from the agenda. Mr.
Second.
Brown, you're seconding. All those in favor?
Aye.
That passes unanimously. And then docket items 8 through 10, 926 Dillard Street, 209 Wiley Street, and 1126 Easton Road, I understand are the city staff requesting motions to rescind. Are there any motions on the floor regarding that?
I'd like to make a motion that we rescind these orders to demolish or repair as they are shown to be repaired by the owner.
I'll second.
With a motion and a second, all those in favor of rescinding docket items 8 through 10? Aye.
Aye.
That passes unanimously. Informational updates. I see we have 815 Pearson Street, Mr. Marple's case. What's going on with that one?
So these are the 2 cases, the historic ledger as well as the rehab ledger cases that instead of the staff putting them on for any hearing or requiring anybody to be here, are just simply parked there. Not necessarily parked to provide an update. They're just parked there and can be pulled from there to your active agenda at any time. But notice has not been given to those property owners to be here, nor that we would discuss their case. So the commission just simply asked us to put them there and let it show every quarter which ones are still there.
Mhm.
In cases that's not yet been referred to the commission, you would never see those cases. These are current that just happen to have already been there because rehab cases are not referred to commission.
So I guess would city staff be requesting that we continue these, or just since this is a new procedure I'm unfamiliar with?
Yeah, so for these 2 ledgers, they're just appearing so that you see that they're there. And then the next 2 months, you won't see them anymore. And then the 3rd month from now, because it's the 1st month of each quarter, they'll just appear so that if there's something happening and the commission wants to hear something and it reminds you that the case is sitting there, then the commission can direct staff, hey, next month, will you give us an update on this case? Because otherwise they're appearing quarterly. Now, if you know they're sitting there quarterly, and like last month, if you want to hear something specific about any case on this ledger, if you'll notify staff, then we'll provide an update at that time. But otherwise, by your request, they're just parked there. Y'all have not asked for any updates on these cases. We just parked them there for your ledger.
And I appreciate that. So basically, this is just keeping us aware that these cases are out there. Inspectors, is there anything out of the ordinary that we would need to know about these cases? Aside from progress is continuing?
No, nothing on 815 Pearson Street.
1316 West Florida Street. They are continues to work on the property according to the inspector, and the property is secured, and the yard is maintained, so it looks great at this time.
Wonderful, thank you.
Just a procedure question, Troy. If we would like to have an update, what would be like a month notice? Would that be, how would we go about doing it? How would we, without being too obtrusive?
If the commission wants an update on these ledger cases, then we can have an update prepared whenever they come onto the quarterly agenda.
Okay.
So if the purpose for the commission placing them there, I need direction from commission so I can make sure the inspectors are here and prepared to provide an update. Their supervisors are here and their supervisors are prepared to provide you with an update if the commission wants one on both of these cases.
That sounds great. Thanks.
And I understand the basic reason for this was we didn't want to have the inspectors going out every month to verify things when these are kind of more long-term projects. So I appreciate staff having designated these as informational updates only. Hopefully that saves staff some administrative burden. So I understand we don't need to take any action on those two.
You're correct.
Thank you. Well, in that case, that was a very quick docket. I believe we've resolved all of our cases for today. So the last thing I had on the agenda was discussion of policies and procedures. I understand the interim director wishes to speak on that.
Thank you, Chair. My name is Cynthia Blue, and I'm interim director of the Neighborhood Development Department. And just for the folks on the commission who don't know who I am, I have a 20-year history in housing and rehabilitation programs and working with the city's neighborhood development department in several of its various names and incarnations. What I want to talk to you today about are two things mainly. One is a quick look at the data and the trends and where we're going. I want to start with nuisances. Nuisances are really moving in the right direction. In April, we had 689 cases. In May, we had 479. In June, we had 339. So for a high growth season, that's pretty extraordinary to be having that much of a difference. And we believe it's due to some of the efficiencies that have been put in place that are allowing cases to move faster through the process. And we'll be continuing to monitor that data to make sure that continues to go in the right direction. Housing, on the other hand, is going a little bit in the other direction. We have not yet done a real deep data dive to figure out what's driving it. But in April, we had 865 cases in action. In May, it was 874. And in June, it's 906. So that's nearly 1,000 properties out there that could be safe, decent, and affordable housing for residents of Greensboro. So we are going to be taking a closer look at that. It's in all of our best interests to find ways to maintain that housing. And to that end, I have been listening to your recorded meetings, reading the minutes from the last meeting and some of the correspondence that has been sent to me. And I want to talk to you a little bit today about policies and procedures and also get your feedback into what I'm going to say and what your thoughts are from your lived experience on this commission. And I'm going to start with what I'm calling the doesn't do anybody any good list. Punishing purchasers with fees and fines who buy property that's under an order to repair or an order to demolish, and then they repair that property in a reasonable time doesn't do anybody any good. And what we are proposing is that for properties that have an order to repair, If a purchaser buys that property, fixes it within 120 days, we would waive all fees and fines. If they buy a property that is under an order to demolish and they fix it within 180 days, we're assuming that those would be more complex cases. Again, we would waive all fees and fines. The next one on the list, and I don't know whether the chair wants to have discussion. I've got 5 on my list. Y'all might have some more on your list. Whether we want to talk about these individually or you want me to go through my list and then we'll talk generally.
I'm thinking it might make sense to go through your list
All
and
right.
let's get everything out there, then we'll have a discussion.
Okay.
Commissioners, do you agree with that?
Okay.
And just since we stopped, I wouldn't have interrupted otherwise. Are these things that you're talking about that you can do?
Yes,
and
these are
under-
within policy. We are not, at
This
this
is a
point,
council decision or I know we don't have the right.
we
but you can
are,
do it.
we did ask for 2 months grace from the commission on those 2 earlier properties because it is our anticipation that we will be going to a council work session in August to talk a little more globally about what's going on in neighborhood development, but that this is certainly an element of it. And because there is such strong council interest in Minimum Housing Standards Commission issues, we want to make them aware before we leap out there. There is still that interim in front of my title.
Absolutely.
Thank you.
The second item on the list is punishing low-income homeowners without offering a functional repair program that they can access. Doesn't do anybody any good.
I 100% agree with you. I think that we on the commission have been kind of baffled with over the years. I know Peter and I and Carolyn, we've been on here a long time. We've definitely locked horns on a couple of occasions on other issues, but one thing we all uniquely agree upon is that, you know, we shouldn't be punishing the poor for being poor.
Mhm.
And if I'm not mistaken, a very famous playwright once said, "You have no idea how expensive it is to be poor."
Mhm.
And this is one of those things where it baffles me, and it's baffled a lot of people on the commission to my right and left, that we don't have programs that are sustainable to fix up the houses to keep people off the streets.
Mhm.
But we
Well
have,
said.
yeah,
Well
like,
said. Thank you, Quentin.
so I'm glad that the interim director is challenging that.
Mm.
And I'll be candid with you, I had many an argument with your predecessor about this, so much so that he stopped taking my calls because I used to argue with him quite frequently. And then it used to get pretty bad on the phone calls, but I'm glad that you guys are looking. It doesn't do anybody any good to put poor people on the street or to ruin a family's wealth system. And most of the time, I'm talking about homes.
Yeah, it is not equitable, and currently too many applicants cannot qualify for our rehabilitation programs because they're loan-based. And so we are looking at grant-based programs that could assist in cases like this. Now, that is a programmatic decision that would eventually go to council. And it still probably wouldn't help everyone. There will have to be parameters around it, but it will help a whole lot more than we can help right now.
And is the main issue of them not qualifying for loans, is that credit-based, the low income?
It could be a number of things. It could be unclear title. It could be outstanding liens and judgments. It could be income issues. It could be things that bar someone from able to participate in a loan-based program.
I know, I was told a lot of times that air properties were one of the big problems. And,
We see a lot of those.
yeah, and I was told that before I was ever on this commission when I was working on the issue. And we have seen a number like that.
Mhm. Yes,
And
ma'am.
so I hope that you can create some program, and it will take some level of dealing with the bean counters on how to do it, but
Mhm.
you just got to look at it, I think, from a common sense standpoint, that if, you know, someone passes away, and if someone called you today and they had a 28 bedroom, 14 bathroom mansion, but you got to redo the plumbing in there, that could bankrupt you. You're like, well, I didn't ask for this. So we got to think of ways, you know, to all have the same goal, which is the goal is to make affordable housing for everyone. That's the goal. So we just got to figure out how to work together to do that.
The third item on the list is bringing housing cases to the commission with year-old data due to pandemic delays and continuances. Doesn't do anybody any good. So
Very much agreed.
we will be considering options for reexamining or restarting cases that have been held up by the pandemic conditions. And we should have that process planned out within the next 2 months.
Wonderful.
The fourth item on the list is allowing properties under an order to transfer ownership without notice to potential purchasers. Doesn't do anybody any good. So we will be looking at the use of a lease pendants filing after the order and appeal process to put the notice on record for potential purchasers that there may be an issue with that property.
And I'll say I'm very much in favor of that. We've had so many cases where a buyer comes in and says, I had no idea that this proceeding was happening until after I purchased the property.
Mhm. And the last that is on my list for now is taking cases to the commission for an ordinance with no plan for resolution and not employing all of our available resources. Doesn't do anybody any good. I may have to repeat that.
My apologies. Could you repeat that?
The last one that I have on my list is taking cases to the commission for an ordinance with no plan for resolution and or not employing all of our available resources first. Doesn't do anybody any good. And that we need to work harder on the front end for resolution, and that we need to bring cases to you where we have a plan for resolution.
Absolutely. Thank you very much for that.
And the time that you've been sleeping since you've been in this position. This is amazing. I think this is amazing.
Mhm.
And-
I'm very
and
much in favor
just
of what you
Thank you so much.
proposed.
What I have heard from your recorded videos and your minutes and the things that you have sent me have really centered around procedure questions, policy questions, and equity questions. And that's what we are hoping to address with the changes going forward. And I'm welcome to entertain any additional comments or thoughts from the commission, from your experience.
Well, my first question is, how can we help you? Everything you're saying is your decision, right? You can.
Correct. There was nothing in that that is ordinance
So you
related.
have Troy and his wonderful staff, and you have Tony and whatever he can add.
He keeps me legal.
Yeah, he'll keep you legal.
That's a good
So-
thing, hopefully.
So what can we do? Or is there anything we can do
Well,
besides not bug you as bad as?
No,
You gotta admit, I've been nice since you've been director, you know?
Your support will be necessary. We will be going to council in August at a work session with a number of these changes to be outlined to them. We know that they have concerns about this commission and processes and the way that they might want to see things go, and we need to hear their concerns as well.
Okay.
Can I just add a little bit more work? I'm sorry.
Go ahead.
What you have there is music to my ears. And I think it's really wonderful that the way you've addressed everything is exactly why we've made the decisions we've been making, because there were not things in place to make us feel that, people coming before us were in a safe place. What I would really like to hear is, because we have, and I'm quite sure we have 900 cases. I'm sure not all of them need to come before us, I hope. But we haven't really seen any cases in a good while. And so with changes in procedures and policies, what is going to be the spin up? How are we going to handle the cases that already exist? Going forward, these are fantastic, but how do we implement this for cases that we've already seen and continued, mostly because of the pandemic and other issues like that?
Right. That is one of the things that we need to go back and take a look at. What is the path to resolution? If a property is basically almost already done and meets the conditions to be rescinded, then you don't need to hear that property again. And if the better path for resolution is to stop and start over in order for you to have full and complete and current conditions to consider, that may be the path to resolution. But we need to take a look at that on a case-by-case basis and make those determinations.
Mhm. And I really appreciate that you use the term equity, because I feel there's a difference, and this is a subtle difference between equality and equity. Equality is the same procedures apply to everyone. Equity is we take into account every individual's particular circumstances. And I think us as a commission are concerned with equity, that people are treated fairly.
For the numbers you gave, and I appreciate kind of the bigger picture, because oftentimes I think when we listen to cases or we hear a particular this and that, we're never quite certain how our decisions are affecting a bigger picture. So when you're talking about nuisances being down, and these the housing cases that you were saying that were going up, those were, what was the specifics?
We need to look into that data a little more closely. I mean, there's some level of cases that churn. They come into the system, they
okay.
get fixed, they go out. But what is driving the increases, whether it's cyclical, seasonal, whether it's an increase in cases being called in, we need to take a look at that and see what's driving it right now.
Right, and just to add to Chairman Isaacov's point, if you guys are also looking at, and I assume you are, of, the districts that these houses are in, and if we could get information like that as well, I think that kind of information just generally helps us understand what we're doing, and so that I think most of us understand sitting on this commission that, yeah, a very high percentage of these cases are in District 1 and 2, with occasionally other districts being in there as well. But again, it just gives us a sense of the bigger picture and where, as the city's addressing these concerns, as you're addressing these concerns too, that we seem to be seeing the same thing.
As a former researcher, one of the things that you're not going to really be able to do is tease out what was caused by COVID. So your data is going to be, until you're 10 years out, your data is going to be kind of questionable. But I think it's really important to look at it, and anyway, as deeply as we can, and always know that, I mean, there are going to be so many things like this that we're just not going to know for a while.
Well, one of the things that I think we also need to look at, since we're looking at policy, and something that we can look into as well, is how some of these complaints are coming in. I think knowing where it comes from is important. Since I've been on the board, it's kind of been like an anonymous thing, but I feel like we should base the name to the complaint. And here's why. Now, arguably, the rationale behind it before was, we don't want to put somebody in a position where they're saying something and we record it. But I feel like in certain situations, we need to know, and the person who is having this complaint made against them should know who is complaining. If you go to court, you're supposed to know. You can't just have a random person do that. And this is a quasi judicial board. I've never really truly agreed with that. And I'll be quite frank with you. One of the reasons why I've always believed that we should know where that's coming from is because in the terms of desegregation and integration, if you say, basically, we don't know what happened, we don't know how this is, but this complaint just came in from anywhere, that leaves a shadow of doubt that there could be a racist tie behind it. For whatever reason, it could be that the people are out to get me, the department is out to get me, and I'll be candid with you. A lot of these people that are in District 1, District 2 frequent my uncle's plumbing shop, and that's what they say. They say the city's out to get me. Someone made a complaint. That's what we never know who made the complaint, just someone. And I've always thought like, that's interesting. If someone has the wherewithal to call it in, then they should be able to leave their name or an address or something that could also identify where that is. That doesn't happen now. And basically all the complaints are pretty much anonymous. Like if I complained about you, the city wouldn't say, well, Commissioner Brown complained about me. I've never known that. Go ahead.
There's some protection under the public record laws from the identity of a complainer. I'm saying that in general. I don't know if it specifically speaks to someone who initiates a complaint for a minimum housing code standard, but that's something we can look into to find out. That information may actually be protected and not be available to the public or to the commission as a matter of law. But I'll look and see if that can better answer that question.
And I could see differences, and I know in the past, we've handled cases with different approaches when it's a tenant who's complaining against a landlord versus a neighbor who's saying they don't cut their grass. My neighbor doesn't cut their grass. And those are very different cases. And I think there is merit to knowing where this originated from. What you're getting at, Mr. Brown, is in law, there's the idea of habeas corpus, which is you have the right to address your accuser. And I know we're not a court, but we are a quasi judicial body. So I wonder if, under habeas corpus, if we can say, if you have a complaint against your property, you're entitled to know who complained about it.
I'll look at the law to see if I'm gonna look at the public records law first to begin with. I'll look at see if there's any case law to where the Minimum Standards Commission would be entitled to know who complains.
Mm-hmm. And specifically, the owner would be able to know who complained about it.
I'll look and see if there's any case law governing that. As far as you're concerned, I think as far as the commission's concerned, where the complaint originated from, I could make an argument that's irrelevant. Really, what's relevant is what's the evidence that the inspector is presenting, and can that evidence be upheld? I'm not sure if the identity of the complaint would have any relevance on that. That's me thinking out loud, which is never a good thing, but I'll look at the law and see if I can find some better guidance.
Because I know we do, when we look at the equities of the case, that's something very much to take into effect. When it's a tenant who's saying, I'm living in this property, this is a horrible condition, I'm complaining against my landlord, we take a different approach as to this is a low-income homeowner who is trying but just doesn't have the resources.
And we've actually, I can honestly say, we've seen some cases like that where the whole tone of how we even thought about it was different when someone was here like, I paid this guy and I'm paying for it. And they just want, there's a hole in the roof, as opposed to the person who's like, my mama died and I had to pay for her funeral. I don't have the money to take care of that. It's totally different.
And I think what's going to happen going forward is that's as the cases are presented to you going forward, I think the difference you're going to see is you'll get, and this is going to go into a little bit to the discussion that I wanted to have with you in the memo, but you're basically going to get two questions. It's an appeal of an NOV, notice of violation, should it be upheld? That's not allowing the city to go onto the property and repair or demolish. That's just upholding the NOV, and there's the property owner is still very much in control of the property and making repairs. Then there is asking you for an ordinance where the city can go onto the property and repair or demolish. Much bigger hurdle, much bigger issue. And at that point, it should be more obvious from the evidence that the property needs to be repaired or needs to be demolished. And I don't think you're going to have that be faced with the question of those cases in between of what do we do with this, with this property, or what are the equities? It should be obvious, and the appeal is just a much simpler question. So I think the way we present the cases going forward is likely going to eliminate a lot of those concerns.
Okay.
I hope that makes sense.
Yes, it does. Yeah, thank you. Well, I suppose our interim director has presented a pretty good framework of discussing these various issues. I propose she gave 5 points, just going one by one through them. Commissioners, what do you think of that? So the first one was punishing purchasers who might have been unaware of housing code violations, unaware of these proceedings. If someone buys a property and it's before us and it has pending violations, I understand the policy that you're proposing is giving them 120 days if it's a repair order and 180 days if it's a demolish order. I very much appreciate that because, and it might make sense to tie into that the discussion about the lease pendants, because we have so many homeowners who come in and say, we've purchased this property, we had no idea what we were getting into, we're over our heads on this. And you can't really fault the purchaser because they're not the person who allowed the property to get in this condition. But at the same time, they're the owner of the property and we want them to fix things. So I'm gonna open, this is number points 1 and kind of bringing in point 4 of notifying purchasers of.
I think that's wonderful. That absolutely should be on the deed. It
Mhm.
just should be, or in part of the closing process. I get, sorry, I need to back up. My brain just went completely blank. Would that, I just want to get some detail on it. Would that basically take them out of the circulation of this process for 120 or 180 days, depending on what they?
It depends on whether it's a waiver or an exemption. Whether the fees and penalties would continue to be applied, and then if they correct the violations within those timeframes, we would wipe them out. If they continued on past what we were considering to be a reasonable time for making those repairs, then the fees and penalties would continue to apply.
And so just to be clear, this is a change of our penalty procedure because previously it was reduce it to 500.
Right, this
So
would
now we're
wipe it to
saying,
0.
okay, zeroed out if it's done within 120 or 180 days.
And is that only if a house is sold after it's been?
Correct, and it would have to be sold to a
new owner.
non-interested party.
Gotcha. Okay. So not your brother.
Right.
Okay, I understand.
And in terms of the lease pendants, I very much like that idea. I know that creates some more administrative work for staff. And I apologize for that. But just for the other commissioners, so a lease pendants is a document you file with court. It's not a court proceeding per se, but it's putting the public on notice that there's some issue that impacts the title to the property. So when a property is sold, a closing attorney does a title search, they'd find that lease pendants, and then they'd know that they can tell the buyer, there's this housing commission proceeding pending. Buy it with awareness of that. So I think that's a good idea. We see so many purchasers who come in, and if there's nothing on public record, a closing attorney isn't going to find it.
Well, this also takes that argument out of the discussion as well. So keeping everyone honest. So.
Is there any further discussion on policies related to purchasers of property while proceedings are pending? And I guess I'll ask city staff this. I think these are good items to discuss. Is this something that we would ultimately vote on today as a commission?
No,
Or just
these
discussion?
are internal policy and procedure issues. We're
Mhm.
making you aware of them. We want your feedback on them so
Okay.
that we can move forward with implementation. We will take them to council as well because of the high interest in council members in the proceedings of this commission and our department.
Mhm. And I think ultimately, since the city does have lien rights, if fines are unpaid, that does affect title to property. Because there could be a lien on the property if there were an order to repair and the city sent in
we
repairmen,
did.
sent in contractors, the city would put a lien on the property for the price of the contractor's invoice. That's something that affects title to property.
Yes.
So therefore, there should be a lease pendens, just like if there were a, a pending foreclosure or a pending lawsuit involving title to property. I think this is cloud on title potentially.
If the city was doing the work, the ordinance creates that notice and title as well. So, and the city can't do the work unless you issued an ordinance. So the ordinance would have done the same thing. The lis pendens just gets it early, right at the point of the, I think at the point of the NOV, rather than having to wait for an ordinance. So it's just much earlier notice.
And I think that's a good thing. I kind of see it similar to there was some recent legislation, maybe 5 years ago, about mechanics liens and about the hidden lien requirement. Basically, since mechanics liens, if someone like a plumber does work on property, they have 120 days to file a lien. If a property sells within those 120 days, the lien's not on public record, and that's a cloud on title. And our General Assembly over in Raleigh said, well, we need to have lien agents. We need to get the notice as early as possible so that we can be aware of that, because we don't want buyers left in the lurch. All right, well, seeing no further discussion on that issue, the second issue that our interim director brought up was the issue of punishing low-income homeowners without giving them resources to city resources that could potentially help them. So I'll open that up for discussion.
I think that's a good thing for them to be doing. One of the multiple arguments I've had with city staff and council members is this idea that everyone can just walk into a bank and get a loan. Like, most of the time, we all understand how loans work. And so I think that if the city has a requirement to have something a certain way, then I also believe that the city should have the resources to help that individual meet that requirement. I think that's critical. We do take in city funds and taxes, and we might as well put it towards the betterment of our environment and community. But I definitely think that I've always believed that it's a city task. If it's your requirement to meet a standard, then you should be able to have certain things to help that. And I've never really truly agreed with the loan program because, like I said, not everybody qualifies for a loan. And nowadays, if you have student loan debt, which we're going to start seeing younger buyers, is what's going to happen. Some of the buyers we've met were younger. That's going to hurt you a little bit with the student loan debt. And I think that's a national crisis that Americans are going through and will be going through for the next 10, 20, 30 years as we try to mitigate student loans and student loan debt, as well as being able to buy a home and create a future for yourself. So hopefully the city will be able to figure out where these funds can come from, because I'm sure that there's also, people who want to work. It's a big circle. You got people who want to work and do stuff. You got people who need stuff done. We just got to find that critical, who's going to help pay for it, and realizing that, at the end of the day, you might not make, for the workers, you might not make as much, but you get experience. And for the people who need it done, you might not get, a marble shower, but you'll get something. You'll get it to work. And, you just have to understand that. So.
And I'd like to add, when you're doing the list, and I'm sure you would do it anyway, but to put in the nonprofits that are available. Of course, now a lot of the nonprofits are getting city money, then some of it, once the COVID money is finished, it won't be happening that way. But I know in the past, some of the inspectors have been really good about helping people understand where some of the nonprofits are available, and there've been referrals that people have actually called in to places where I've been a consultant and said that I learned about this from from a code inspector. So I think that there's a lot out there that changes. I mean, it's changed so much during COVID.
We're actually working on a postcard sized version right now of resources that code inspectors will have in their cars that they can hand to.
Beautiful.
Fantastic.
Beautiful numbers and websites.
That would just be beautiful. I mean, I know a lot of them have been doing it for years, but anything to make it easier, particularly because things change so much in the nonprofit world.
So I think to the point that Commissioner Biggerstaff was raising and the idea of the card, information card, I think we've heard plenty of cases where residents have come before us and they weren't aware of this program or that program. And I know that Troy and the inspectors have been working hard to inform, to give people this information and so on. Not that this is going to solve all the problems, but I think it would solve a bunch. If the city was again to look very, very hard at the language, interpretation, special needs, et cetera, in order for residents to fully understand the programs that are out there and so on. And again, this is not to burden our inspectors with more stuff. I think I saw Inspector Soven on one of the City Speaks language programs, which was kind of neat, learning Spanish, I guess. You know, but again, not to put all the burden on the inspectors all the time, but the city has to recognize in general that, and not just housing, a lot of the issues, for better or worse, have to do with residents actually knowing that this or that outstanding program is there. And I've gone through sometimes just through the city website and I'm looking at stuff and go, I didn't know that was there. So that informational piece may not reduce all these housing cases, but maybe it'll have a stronger preventive effect, so that the housing, the nuisance issues, all those kind of things that are coming before Troy's area and eventually before us don't happen. So I'll just come to that point about the informational stuff and making sure it's put out there in a form that a lot of folks can understand. It may be a language thing, and also those who don't read. I think Reading Connections usually uses the number like 20% of our, I think they use the county. Guilford County is, it's reported that adults do not read to the level that I think that they use it somehow, the level that they would wish, which doesn't make them functionally illiterate, but it means that they don't feel that they can do the things they need to do as adults. I don't know if that number still holds up, but again, the idea that multiple ways of communicating this stuff, different media, et cetera, it's different languages and so on.
And Lord knows some of these orders and some of these instructions, they're put in legalese that's hard for even a person who's college educated literate to understand.
I agree 100%.
And what I see, and I'm thinking out loud here, commissioners, I know we can't make any formal decisions today because that's a city council decision, but I know we are tasked under our ordinance, aside from hearing cases, we're supposed to study rental rates, the need for reconditioning or condemnation, and other housing conditions within the city, and make recommendations to city council concerning such matters. So what I'd see as a fruitful end of this discussion is making a formal motion that we request city council to address these issues that you've brought up. Do you believe that would be helpful in your endeavor?
Sure. I don't think it would hurt.
I think we're generally in support of what you're proposing, and maybe if we have a motion saying, yes, we think these are good ideas, that's something city council could consider. Year-old data was number 3. I wholeheartedly agree. I want to see the condition of the property as close to today as possible. And I know our commissioners are good about generally within the week before a hearing, if a case is before us, going out and taking the video, walking through it.
I definitely agree with Peter. I think that you're going to have to put I think you're gonna definitely have to put some thought process into as well, that we are coming out of an unprecedented time. So you're gonna have to have an unprecedented protocol system that's not gonna hold people to the screws of that. I mean, I can candidly tell you right now that there are many service companies who 100% cannot provide the service to the people that they are. I mean, my service department has 5 guys in the field, and we legitimately work at least 12 to 18 hours a day each truck, and that's unheard of. And it's causing inflationary rates in the service industry. So nowadays, if you want, what would probably cost you something less? What did a lady tell me yesterday? Yesterday, a lady called us in, and literally she said, "I need a quote for a toilet." My uncle gave her a quote, very reasonable, because you know we're not going to charge that much. She said, "That's good." My uncle said, "Out of curiosity, what was the quote you had before?" She said it was $900 for the labor, and they couldn't get to it till next week. And that's what's starting to happen, is that there's just not enough people to do the work. And so it's almost, you know, in certain cases we see where, you know, people are trying hard to get it fixed. And they'll say, "We just can't find a person to fix it in this time frame." We just don't. And I think that's something that the city, I guess that's something that the city needs to take into effect. That's how it's going to be. Not to mention that we've also had many cases where there's no material, and they'll say, "Hey, you know, even that guy, you know, we talked to that one guy. He said, you know, we couldn't find any wood to be able to build what we want to get built." He's like, "Well, I would have had it built." So I think that, you know, you're going to have some grace periods, maybe even longer. And I know the city attorney says that there's some ordinances that are in there, and I guess you'll have to talk to city council on how they can adjust the ordinances, not just for the next couple months, but you're probably going to have to adjust it out 24 months, almost 2 years out, where you'll be given enough grace period for the world to open back up. I think that's definitely going to be a challenge in itself.
I'd like to continue that support on what you just said, because I have 2 clients. One's in the home building industry and one's in the pump, pipe, and sales industry. And they literally cannot get product. And when they do get it, it's a good 40% higher than it was 2 months ago. So just the cost on things is and what's available is very difficult.
And
so it's just a continuance of what we have seen. It's going to take a while to get out of that. So we need to make adjustments for that.
And without giving out any specifics, but we saw a case that we upheld the inspectors on something, and it dealt with a family that was poor, and they decided to go with another they went with a company that could get them within the specified time frame that would get them out of trouble with the city. And I'm not going to tell you the name of the company. I'm not going to tell you the case, because we're not supposed to do that. But I'm going to tell you how much money they paid, because I know this for a fact, because I talked to the owner, because he actually came and talked to my granduncle about it. To fix 2 bathrooms and a floor, they're $36,000 in. And he's like, "Well, I'm gonna be honest with you. The city said they, you know, I was afraid they're going to demolish my house and put my family on the street." And you don't want to be in that. Like, none of us on the commission want to be that leverage that the city puts the screws to somebody on. And that's just the truth. I'm not exaggerating. You can call this guy and say, "How much money you spent for that?" And the company was like, "Oh, you know, we got lifetime warranty on work." But what you're going to start to do if you're not careful is you're going to make it's almost like you're making a market that a person can't bear. You understand what I'm saying? Like, they're so afraid of what they're going to lose that they'll sell their soul to get out of trouble. And I'm talking to you now on a humanitarian level. You don't want to have a system or any department that's so feared that people will lose their soul to get out of trouble about it. And you don't want that. And I'm not, when he said $36,000, my uncle looked at him and he called everybody and he said, "Say again." He said, "Yeah, well, I signed a contract. It's $36,000. And there's no way they're doing that level of work. The house probably ain't worth $36,000. But they were so afraid after being on this commission, after being on this Zoom call, that the guy said, he said, "I'll probably never live long enough to pay them all out." And he literally said those words. And that's not something that I think anybody on this commission wants to be a part of. And I don't think you're going to get anybody on the commission that's going to want to be a part of that. And that's something that the city has to step back and look and say, what are we really truly doing? Because you're the enforcement arm, and the enforcement arm is going to scare a lot of people, because you're exactly right. A lot of people don't read. They don't know. All they know is, I could lose my house. I could be homeless. That's a very powerful fear to be on. And you need, as a department, I think even the inspections department should sit back and look at that. Because that's pretty exorbitant. And like I said, I'm not exaggerating. I will take you to the guy's house.
And I wholeheartedly agree. And I'll add, and I know I've said this before, but especially for low income individuals, home ownership is a key out of poverty. Owning a home generates generational wealth. Owning a home, even if you have a loan, you're paying the mortgage and part of that money's going towards equity in the home, as opposed to rent where it's basically money out the window. So I don't want to be in the position as a commission where we're saying we're gonna, in essence, take your home that you've fought for and worked really hard for away from you. Even if that's not the intention, if you get things like that $36,000 bill, that's gonna take away home ownership from someone who fought very hard to acquire that home. And that's a key to increase people's status of living out of poverty into, a decent standard of living. So I agree with Mr. Brown.
This might be jumping ahead a little bit too much, but I remember that during, I think it was last fall, we had a Zoom training. And at that point, the receivership program was discussed. And to the point about people losing their wealth. I understand that if we go to that stage where a house was actually, I think, if I understand technically true, we would approve it, that it would go before the Superior Court, et cetera. There was a concern about who the contractors were to do such work. And whatever the city's position was on the minority, the MWBE. And at that time, I think there were still, I don't know the technical word, the contractors who would, the qualifying contractors. I think there was a good, I think Commissioner Brown had the concern that there was a certain number that qualified under the minority and women, but a real distinction being made, or a couple of distinctions being made about whether those contractors couldn't be from the actual districts that in which the work was going to be performed, or if the contractors were actually minority versus just women, which could be, I think it was pointed out, white women owning businesses and so on. So, but the overall concern was that there would be more inequities promulgated through this, and I'm just pointing this out because I think we have not ever gotten this is still a pilot program of 20, if I remember right. This would be 20 examples on which the city would determine this is looking great, this is not so good. But we actually haven't heard any, I don't think anything has actually come before us. So it might be a little bit theoretical, but I think it comes back to this point about concerns that families, the ultimate worry was that a family would actually lose property, would lose a house this way through an eventual foreclosure or some other means, where the place was fixed up, but they couldn't afford to essentially get out from under the monies that they would owe to have these repairs done and so on. So that's maybe going a little bit far out, but because we haven't gotten this case yet, and it's still in a pilot stage. But I think this reflects an overall concern that we have about essentially punishing low-income folks, especially punishing folks who are in districts 1 and 2 who would, I guess, statistically be likely to be among the first to be showing up in a receivership program if we get to that stage.
I also agree with Commissioner Young. I definitely think that the receivership programs are very, candidly speaking, dangerous program, because once you read into the fine print, it is definitely, I see what the goal is to get the houses in compliance, which is the goal of it. But the question is, are you willing to take someone's wealth building station that might have been in the family for generations and put a new roof on it and put them in a position where they lose everything, which is really what's going to happen. You read the fine print, that's what's going to happen. And I'll be candid with you. I believe the first time that happens and it gets publicized by the media, that this is what happened, it'll put the city in a bad place. It'll put the department in a bad place, and it'll put everything in a bad place, because the court of popular opinion is going to look at it and say, did you just take someone's house because they couldn't afford to fix it? And that's one of the things that I think we'll be very careful to be playing with.
Can I make sure I understand your concern? Because I think I share it.
Yeah.
So hypothetically, let's say there were housing code violations related to a roof. Roof costs $10,000, $20,000, $30,000 depending on the house.
Right.
Homeowner, there's a violation. It's clear there's a violation as to the roof. Homeowner can't afford that repair. So basically what we're talking about is kind of a form of gentrification where they can't afford it. So the city's going to come in, and then the city's going to kick them out, and someone who can afford to make the repair is going to do it. But the externality of that, previous homeowners who were building up their wealth, going from poverty to, a reasonable station,
Correct.
they're left in the lurch.
And really what happens is the city's not going to fix it. The city's going to allow the courts to walk in and appoint somebody to fix it that may not look like them, doesn't live in their area. And after they do fix it, the person who originally owned the property has to pay the person who fixed it what is owed. And if they don't, the person who fixed it will either A, they'll work out a deal, or B, foreclose on the property, get the money that they put into the process, making it so that the person who owned the property loses the property because they fixed it. And the city kind of sidesteps it. So what they did was they sidestepped the selling process. They just went there and fixed it. And the person's able to say, hey, you know what? You owe me this much money. If you can't pay this to me in 2 years, then
It goes to some developer or something like that.
this house probably will be mine.
And this kind of goes nicely into point number 5 that our interim director raised, which is when we deal with cases for folks where due to money or whatever reason, they don't have plans because they don't have the resources to fix it. And it's just one of those, we can say there's these violations, we can say we want you to fix them, and they'll agree, yeah, there's these violations, yeah, we want to fix them, but they just can't for one reason or another, whether it's air property or people with just limited means. So how do we address that? No question.
No, it was very,
I just proposed the question.
very easy. The answer is easy, but it's not easy to implement. Let's fund it.
And that's another question. Where would the money come from?
So, pointing at the city. I do want to make a couple quick clarifications. Troy let me know that of the contractors who have been approved for receivership, 3 are currently MBE and 1 is a potential MBE that's going through the process right now. So all 4 approved contractors are MBE corporations. And receivership is a tool, but it is a tool for only the right situations. It is not a tool that would be indiscriminately applied to all situations. And that's one of the reasons why we call this a pilot, because we need to look at the lists of properties that have orders to repair and orders to demolish on them. What are the situations? What's feasible? a property that needs significant repairs really probably isn't going to be a candidate for at least these early receiverships, because these contractors are probably not going to have that ability to put in that kind of money in a property that does not have value. And so there's going to need to be a wider range of tools that we bring to bear on those properties that have orders to repair and orders to demolish. And that's to be worked on in the future. We're going to attack this list as best we can with the tools that we have.
And I very much appreciate that this is a pilot program. I think the intent of the program is good, and we're just trying to figure out, it's the working out the kinks of the program.
I think it would be nice if we had the bumper rails to know, you know, what would really end up in there. I know that we had a case once, there was a house, we said, went ahead with the order to demolish because we couldn't even find the owner. The original owner had died. We could not find any relative, and I think it had come before us a couple times, and then we said, yeah, it's got to go. Well, so that would be an ideal case, although it's probably in really bad shape, but it would be ideal because it's not displacing anyone from that neighborhood. So
I agree that'd be awesome, but yeah, I think that's kind of what the receivership program was kind of designed for, is when you can't find anybody, then you got to find somebody. You can't find anybody, you got to find somebody. I don't think it was designed for the family of 5. You know, the parents are sick or have cancer of some sort. Everyone's working as hard as they can, and they just can't get it fixed. Like that's not, like I said, that just would not be a smart political move to any politician to push that through. So
I don't know if this is a good place to put this in. But when we finished our discussion here, I wanted to bring this up, but I feel like it's all related. I asked for a request for public records on the inspection fees that had been amassed from March 2020 to December 2020. And the answer I got was a little confusing. It said the amount that had been billed was this dollar amount, which led me to my, being an accountant, that led me to my next question. Is there anything that isn't billed from last year? I hope there isn't, but there may be a possibility. But given that, what I would like to ask our commission to do, and I will make this a formal motion, is to ask City Council to remove those fines from those persons who accumulated them from March to December because of the extraordinary time that we were in at the time, and their inability to get the job done. That being said, I'd like to know how that affects what you're doing, because I don't want to mess anything up that you're doing. So.
In my knowledge, it would not affect anything that I have proposed here today. And that would be a council directive to us to say, wipe those fines.
And Ms. Furman, would that be basically a blanket waiver of March 1st, 2020 to December 31st, 2020?
I think it would have to be, because I would think it would get very messy if we start getting really particular about cases.
Trying to decide who.
Yeah. And given the cases, you know, I know there's some, I had a discussion with a person who sort of gave me a little bit of directive on it. And I don't think there's anyone in those cases that happened between March and December that we would feel not great about getting that. I don't have to say that.
How much money is it?
It's $6,250, I think. It's not a ton of money.
And
yeah, the first number was a 6. That's what I remember.
Right. I think it was $6,250 or maybe $450.
And where would that money, what would it be used for if it was collected?
To run the neighborhood development program.
Actually, it would go back to the general fund.
Oh, it would.
Yeah, that's what I was
Okay.
thinking. It wouldn't go directly to neighborhood development. Okay.
And,
Thank
and,
you.
and just to be clear, that would not include, without naming any names, I don't want to waive penalties against certain landlords who probably deserve to pay.
That was my
Right.
exact thought.
Exactly. And
And I
don't
expect it
think,
was Andrew's thought too.
I don't think we have any of those.
Okay.
I did not get a case list, so I
Okay.
can't tell you.
Because there are certain people that we should collect against.
Oh, absolutely, absolutely. I thought long and hard about that. But just looking back, I didn't see any.
Well, I thought you would have checked that out.
Yeah.
but-
Looking back, I didn't see any.
Just,
But yeah, 6,000 is a lot of money to individuals, but for our city, it's really not. So I think that that's something that would give a great deal of relief to individuals and not be a great burden on our city. So
I'd also propose along these lines. So we have a proposal for purchasers of properties to waive that $500 minimum threshold for penalties if they 120 days for orders to repair, 180 days. I'm just going to put out there for discussion. I think staff and us as a commission should have the ability to take it down to zero if we deem fit. I'm not saying every case automatically goes down to zero, but there's plenty of cases where I think the equities say a person shouldn't have to pay fines, and we say, well, you can reduce it down to $500, but $500 is a lot for a lot of people. And I just like more discretionary authority, I guess is what I'm proposing. So I'm just going to put that out there for discussion.
May I interject from a legal perspective?
Yes.
The ordinance gives you the authority to reduce to the extent that the inspector may reduce. The inspector may only reduce pursuant to the policy.
Mhm.
So if the inspector, if that policy remains in effect, and if the inspector cannot reduce below 500, the question to you is, did the inspector uphold the policy as it currently stands? That's pretty much a yes or no. You would not, the commission would not have the legal authority to go below the policy limits as the policy is defined.
And I guess I'm giving this proposal in the context of recommendations to city council.
Understood.
So I don't think we have the authority to change that. I agree with you. But if we're talking about policy recommendations, that would be a potential recommendation I'm proposing for discussion.
and I want to go back and be sure that is a council decision and not the interim director decision. Is that correct?
That is a director decision, of course, with guidance from the city manager's office, and the council always has some impact, but the ordinance does indicate it's a director decision.
So where does that leave us? Do we need to take it to city council, or do we need to take it to the neighborhood development director? Or both? Is
Honestly,
this one of those things that we should say we're asking it of in-house of you, Ms. Blue, and that we want the city council to know that's what we're asking. I just want to do it right.
I think it becomes very difficult when you start splitting those hairs. What we had proposed for new purchasers who bring their properties into compliance within a reasonable period of time, that they would be exempt from fees and penalties. When you get into trying to decide who's deserving of a write down to zero and who is not, that starts to get much more difficult to write into policy.
And my understanding right now is, so if someone has, let's say, $10,000 worth of fines, the current policy is they could appeal to neighborhood and development to get it reduced to 500 based on them showing receipts for work done.
That's correct.
That rule about reducing to 500, is that by ordinance? Or is that an internal policy and procedure?
Okay, they're telling me it's policy.
It is policy. It is not dictated in the ordinance.
So that's something that could be done at the agency level, the department level, not at city council level.
It could be, we would have to determine again, what are those exact parameters around which we would issue a waiver from those fines versus implementing those fines.
And I guess what I'm proposing is, there's this very, very arbitrary legal standard called good cause shown, which
That's a very difficult standard for governments to apply. Because good cause shown has been used a lot in discriminatory manners. So it's, for the policy of this nature, it's a policy that applies to all. Otherwise, you run the risk of implicit bias, whether intended or not. But I understand the good cause shown. It's just very difficult for a government to enforce that because what's good cause.
And that's a fair point.
Can mean a
And
lot.
so then we'd be relying a lot on whatever city employee is making that decision.
Correct. In the same would apply to the commission. As cases come before the commission, you may very well be susceptible to the same unintended but bias. So that's why a policy is generally written for one size fits all.
And I would feel more comfortable with that being a commission decision, just because we have a lot of different people here with a lot of different viewpoints. So it's not going to be one person making the decision. Perhaps we could propose city inspectors have the ability, or city staff has the ability to waive down to 500. And if someone wants to appeal the 500, then they could come before us as a commission. And I understand that we as a commission could still have bias, but I think just given that we're all from different districts, we all have different backgrounds, there's more safeguards to avoid bias. Could we enact a policy that said if someone wants to waive the remaining $500, they could appeal to the commission and we could listen to the facts of that specific case?
Your question is, can we, meaning the commission, enact that policy? No. The commission doesn't have the authority to enact policy.
Could that be done at the department level?
My recommendation to the department would be no. You would need an ordinance change to allow that process for that appeal to be heard, for the commission to be given the authority to overstep the policy.
Basically, it's an equitable solution to say, if someone wants to appeal, wants to get the 500 wiped out, they can come before us, we'll listen to the facts and the reasons, and we'll make a decision.
As I currently interpret the ordinance, or as the city attorney's office currently interprets the ordinance, that would require an amendment to the ordinance rather than just a change of policy.
How about if the amount was simply reduced to 250 instead of 500? Where would that stand?
I think the question really is for the commission to override the policy to any extent. The ordinance would need to give the commission that authority. And the ordinance currently does not give the commission that authority. The ordinance gives the commission the authority to uphold the policy as determined by the director. And when I say director, I mean conclusively the city manager's office, because I know the director's not likely going to do anything without city manager guidance.
Okay, so but I think if I'm following what Chairman Isaacoff and Commissioner Biggerstaff are saying, we could as a commission, if we wanted to make a motion and vote on it to say that we were in favor of, as a commission, we're not empowered to enact, but we're in favor of either having this this ordinance changed to $0 or $200 or $50. I mean, we can take a statement like that, right? I mean, there's nothing stopping us from doing that. And Interim Director Blue is here, and she can I mean, like, pass on this information and say, well, this is what they thought. has no power of anything, but it is coming from, you know, a city commission, et cetera. Right?
Basically, you're saying make it a recommendation to city
Correct.
council.
I mean, however we want to word it, we feel strongly that, et cetera, et cetera, et cetera. Right? I mean,
Yes, you can always make that recommendation as a commission or as individuals. And I can tell you by doing it now in public, you're making the recommendation because I have no doubt that there are council members watching, but that also Director Blue is going to take that issue back to the manager's office and to council to be considered.
Mhm.
I don't really know that you need a formal resolution. You're happy to do a motion in formal resolution. But it would appear that you're all in agreement, and I'm sure that's going to be conveyed through the city manager's office, potentially to council.
And I'd just say at the end of this discussion, for purpose of formalities, I'm keeping a list, I'm taking notes of our various recommendations, and I'd like to make that a commission motion that's voted on. If y'all are okay with that, just saying
Okay.
these are the things we discussed, this is formally what we recommend, and let city council do with that what they will.
I'd just like to say, I don't have any cases that I brought, but Quentin, I know we've discussed way back a few cases where we would love to have been able to waive any fines. And I know I had in the back of my mind, one of those things I never did about one of our local foundations that could use, could have used some of their money for some of those situations. There are just too many advocacy things to do, and that's one I dropped. But it would be great if we thinking again about some of those cases that were where you knew every penny counted. It would be nice if there was somebody that had that, whether or not it's us. It would be nice if somebody had a way to do that.
And I want to emphasize the $500 minimum threshold currently. So I understand the reasoning behind that rule, and I think the intent is good of you take someone who might have had $10,000 worth of fines, and we have the ability to bring it down to what I think was intended to be a negligible amount. But 500 is not a negligible amount for some people. So that's kind of my rationale for saying, let's give us the authority in certain circumstances, if the facts merit it, to take it down to 0.
I agree wholeheartedly. I mean, we're obviously appointed. We know what's going on. Why can't we take the fine all the way down to where, I mean, what's the point? The purpose is to get the property fixed. That's the purpose. The purpose is not to be fining people. If that was the case, then we probably wouldn't be where we're sitting out here. If the purpose was to make revenue off of it. So, the fine is a fine. I understand that the city wants to make sure they have teeth, that people will do what they say, and I agree.
Mhm.
But if a person sinks $20,000 or $30,000 into a house, I feel like it's going to take some time to recover. And if you're poor and you have to do that, that's some significant resources that are lost. And I think that like Carolyn said, that there's a lot. Why wouldn't the commission be able to? I mean, I would only ask that city staff, and they've already done this before, I'm sure. And I say this to the interim director: just put yourself in the mind state of an individual who honestly lives check to check, and then ask yourself, could I afford this type of? What could I really afford? And I say this to everybody on the commission: go today to your bank account and say, okay, if I got sick tomorrow and I couldn't work for 30 days, or 60 days, or 90 days, what would my bank account really look like? Do I have enough income coming in that I'd be okay? And you'll begin to see how every penny counts, especially if you're fixing stuff that, I'll be candid with you. In some of the cases we've seen, that house was out of compliance, but the house was not non-usable. You see what I'm saying? Like, you still live there, it just ain't, it ain't the prettiest I've seen, but it wasn't in a state where you couldn't inhabit it.
Mm-hmm.
It's only inhabitable because it had this many violations. But in today's society now, especially after COVID, we don't know the ramifications of what's going on. Soon we'll stop, the world's opening back up, but we don't know the recession that might come behind it. So it's something that I think that the board should be able to say, hey, look, you got it fixed. Good for you. We took your fine down to $0, live on and be blessed.
Well, another thing that I always think about is one who's done a million budgets is money not be going. And when you say it's definitely not going to neighborhood development, the fines are going to the general fund, then that matters to me. You know, that matters to me. And not that it's not important, you know, our city's funding, but it's like a penny as opposed to, you know, a larger amount. Because if it's going to the, already thinking, Teresa, especially you, who'll hopefully be on city council, already seeing what we do with the NUSBOM funds now, I don't have a whole lot of desire to give this to the general fund. If we could give it right to neighborhood development, if we could give it to Troy to get what he needs, that would be different.
I think Troy would be happy with that.
That's something to consider. Could we recommend that civil penalties collected through neighborhood development stay in the neighborhood development budget?
Good.
You can recommend it.
So we talk about this, and I thought you were such a sensible man.
And then we can talk about this slide.
Can we take all of that and turn it into a motion, like you suggested?
I think that's a good idea. I also wanted to discuss the memo that Tony raised. And I'll say we usually take a break, and I very much personally would appreciate a 5-minute break.
Could we possibly take a 15-minute break?
15-minute?
A legal counsel requested earlier, that's what I was getting ready to ask. But I will defer to him how long he needs.
15 would be great. Thank you.
So we'll be back at 3:25. All those in favor? Aye. And the agenda will be discussing the memo and potential motion for recommendations.
So just to let everybody know, the meeting is still Zoom. It is still recorded.
For everyone, I'll call this meeting back to order. We're a little bit past, but had a good break. What I'd like to do is we've had some really good discussion about potential policy changes. We've talked about a motion of a recommendation to the council. Put that on the floor and vote on it, and then move into the discussion on that our city attorney has submitted and talk about that afterward. I've been taking notes of all the wonderful suggestions that both our interim director, our staff, and our fellow commissioners have made. I'm just going to read through my notes, and commissioners feel free to add on, correct, change anything Going with the points that the interim director recommended, I have one, we're proposing that if someone purchases a property while it's in the midst of a housing commission proceeding or a violation proceeding, we would waive fees if the new homeowner fixes it within 120 days of acquiring it, if it's an order to repair, and 180 days if it's an order to demolish. So that would be our formal recommendation to City Council. We're also recommending that we create some sort of postcard or flyer with a list and contact information of assistance programs available if someone finds themselves in the position of having to correct violations and they want to, but just can't afford it. The inspectors, upon finding violations, will give them that information, pamphlet, flyer, postcard, however it's portrayed. Next, we discussed that lease pendants would be filed for any pending minimum housing case. That would put any prospective purchasers on notice that there is a pending housing commission proceeding before they close on the property. Tracy has proposed removing, just flat out waiving fines from March 1st to December 31st of 2020, given all the difficulties of COVID, that we're just waiving the roughly $6,000 worth of civil penalties that have been assessed.
Not civil penalties. These are the inspection fees.
The inspection fees. Thank you for clarifying that. And we've also proposed that we would change the ordinance to give the commission the authority to waive the $500 minimum fee down to zero if a homeowner were to appeal to the commission. So I want to be clear that we're recommending the inspector has the ability to waive it down to 500. And if a homeowner wants to appeal that decision to get it down to zero, they can come before us and we would take in the facts of their specific situation and make a decision of whether to waive that down to some amount below 500 all the way down to zero if we deem that fit. So those are my notes of our recommendations. Does anyone have any additions, changes, subtractions?
Can we just make a motion to accept your recommendations, our recommendations as written?
So I'll make a motion that we submit that as a recommendation to City Council. I understand we don't have the authority to decide that ourselves, but we're saying we want City Council to consider this.
I will second that motion.
Don't want to interrupt, but I was just thinking, let's listen to one that makes it speak about a lot of such as one thing that has to be it's way to oh, that this is what we want. Reinforcing.
I think that's fair. And so maybe I could amend and clarify my motion to say, these are our recommendations to the extent that it can be done at the department level. We recommend that. To the extent we need City Council approval, we would recommend that to City Council. I think.
But
I was having a hard time making it in one motion.
But we're recommending these policy changes.
But I think Commissioner Lamont's proposal is completely new, is it not? So
the removal
of the elimination of inspector fees.
Mhm.
So that
would require City Council approval is my understanding. So we'd be recommending that City Council waive those fees. So that is my motion, and I understand Ms. Lamoth is seconded. Is there any further discussion? Right, seeing none, we'll call the question. All those in favor of making those recommendations to both the Neighborhood and Development Department and City
Aye.
Council?
Aye.
That passes unanimously. So those recommendations have been made. Moving on.
Chairperson Isaacoff, you made great notes to make your motion. May we have your notes when you're done? It may help us in writing that up. Don't need it now, but don't run off. Let us have the notes before you go, please.
Yep,
Thank you.
I got them for you.
Thank you.
And I understand Mr. Brown has a matter to attend to. Mhm. Thank you, Mr. Brown. So last on our agenda, we have this wonderful memo that our city attorney's office has prepared regarding burdens of proof and basically the manners in which we determine cases. I guess, Tony, I'll open the floor up to you if you want to give a statement on this or.
Yes, and thank you. And I'm actually going to amend this and email a cleaner version back to you because part of the 15-minute break, we kicked one of these issues around and I think I can better state it in the memo. So you're welcome to keep this copy, but I'm going to email to you a better copy.
Absolutely. And do you want to summarize the positions of the city attorney's office?
I will. 1 second. All right. No, you just took a sigh on that. Sorry. Miss Blue took a sigh and it sounded like I need you for a second sigh. She did not. Yeah. She reminded me she did not kick me because I encouraged her to kick me if she needed me. So Chairperson Isaacoff, you asked about burden of proof and obviously I've laid out the case law and for the sake of the commission, the burden of proof generally for the entire case is called greater weight of the evidence. And so think of the Lady of Justice holding the scales and whose favor do the scales tip? If they tip in your favor, you win the case. That's simply stated the greater weight of the evidence. The evidence for each conclusion, it should be substantial evidence, which the case law basically says is a reasonable person convinced that that conclusion is reasonable. So in the normal case, if we presented a notice of violation appeal to the commission and the inspector had substantial evidence for each element or each violation, and that substantial evidence would be enough evidence that a majority of the commission was convinced that that violation exists. And if the property owner does not present any evidence, property owner may have argument why it's unfair, the property owner may have concern, but if the property owner doesn't have evidence to contradict the inspector's findings or to contradict the photos that you see or the video that you see, then the greater weight of the evidence would be in favor of the violation. And in theory, that appeal would be overturned and the violation would stand. So the legal term of art is substantial evidence for a conclusion, and the totality of the case is a greater weight of the evidence, and it would be a greater weight of the evidence for each violation as well. So you'd have to consider the city's evidence and then the property owner's evidence, if there is property owner evidence, and determine if that violation exists.
Mhm. And I want to be clear. So when we apply that standard, my understanding is we apply that standard to the condition of the property as of the date of hearing.
I'm gonna get to that.
Okay.
Good question, and that's gonna lead me into what are the issues to be determined, which is number 2. And before I go there, did any of the commissioners have any questions about the burden of proof or the standard that's required for the commission to uphold? And what I want to eliminate, let me give you a little more perspective. In legal speak, there's greater weight of the evidence, there's beyond a reasonable doubt, there's clear and convincing. Mr. Isaacoff knows these phrases because these are common phrases and you have these beaten to your head in law school. Think in terms of percentages. Greater weight of the evidence is 51% chance you're right. Burden of proof is generally better than 75% chance you're right. That's criminal court. Clear and convincing is I'm convinced. There's no other doubt. I'm convinced. Very high standard. So the standard for for a decision before this body is simply the scales tip in favor of one side or the other.
The 51%.
The 51%. Yes. Any questions about that? All right. So if you look at number 2, what are the issues to be determined by the MSHC? And I think this is going to tie into earlier comments about cases coming before the commission. So in an appeal case, and we'll start with the notice of violation appeal, and an inspector has issued a notice of violation. An inspector has had the administrative hearing and has upheld the violation that he has issued. Most commonly, that's going to happen. Property owner appeals that decision to you. In theory, that appeal is going to get to you pretty quickly. One, because state law and the ordinance requires that it be held in a reasonable time. The evidence before you is the evidence at the time the NOV was issued. Does the evidence support the issuance of that notice of violation? And I want to distinguish the notice of violation from an ordinance.
Can I interrupt you 1 second?
Please.
Have we ever seen one of these cases
An appeal of an NOV?
of an NOV?
I assume so. In my short tenure, I don't think you have, but I'm assuming the Housing Commission has at some point.
Yes, there has been in the past, and there is a couple that are pending.
All right.
So just to clarify, this is when the hearing has occurred and they've had a period of time to complete it? No.
No.
They just flat out disagree with what the inspectors found and they're coming to us to appeal
And
it.
it is a great question because that helps me to explain the difference between there's an NOV appeal and there's a hearing for issuance of an ordinance. The issuance of the ordinance only occurs if the property owner has failed to repair, demolish, or vacate or close the property. Clearly, if there's a failure to do so, there's going to be some period of time. And at that point, the city needs to act to close, repair, or demolish the property. So until the city is prepared to act to do those things, an ordinance is not necessary. At the NOV stage, the only thing that the commission is being asked is to uphold the notice of violation based upon the evidence that exists at the time of the NOV. The property owner remains in control of the property after the NOV is issued. And unless the property owner voluntarily vacates pursuant to a condemnation order, property owner is in the house and they have the ability to repair or to demolish. It's the point where the property owner fails to repair, demolish, or vacate that staff would then ask you for an ordinance so that the city may repair, demolish, or vacate. At that point, the standard is what's the condition of the house at the time of the hearing?
At the time of the hearing before the commission?
Yes.
Okay.
Because you think about it, if the NOV is not appealed, the order stands, and the property owner is in the house and still in control to try and effectuate that order or demolish, there's some period of time. Good possibility they've done something. And if they have done something, but at some point they have stopped to the point where the city staff now comes and says, we need an ordinance for the city to effectuate this repair or demolition. You need to be convinced, and here's where the due process kicks in. The state law requires that you review the case to make sure that before the city comes onto private property to do this, that the condition of the property is such that there are more than 5 minor violations or 1 major violation that the property is unfit. It needs to be either repaired or demolished. You would want to see the property at the time of the hearing to make sure that the condition of the property is such that you would issue an ordinance to allow the property to do that, allow the city to do that.
And that's an important point I want to clarify. So over my last 5 or 6 years on the commission, we look at a video that's taken relatively close to the date of hearing, And then if there's been improvements since the video, the inspector gives testimony saying, yeah, since I took the video, they painted the walls or they did this. So in my mind, what we're concerned about is that point of, as of the date that we're deciding the case, are there violations? What's being done? And we rely on a video taken close to the date of hearing, and we rely on the inspector's testimony.
If the question is an ordinance, you're correct.
Mhm.
Yes. If it's an appeal, then it's as the date of the NOV. But again, the hearing date should be close enough to the date of the NOV. There's not going to be a big time gap to where you need to see a current video. In theory, you're going to be within 30 to 60 days.
But our goal is to understand the condition of the property currently.
If it's an appeal of an NOV, the only question is, does the evidence support the NOV as issued by the inspector, the date the NOV was issued, if it's an appeal of an NOV? And again, that's just upholding that inspector's notice of violation.
But most of our cases that we see are requests for ordinances.
And that is likely what is going to change, because unless the city is ready to repair or demolish or must force the house to be vacated or closed, we don't need the ordinance. That case isn't going to come before you. So you'll see repairs and you'll see cases when the city is ready to vacate, close, repair, demolish. That'll come before you. And at that point, in theory, the evidence should be pretty obvious as of the time of the hearing. The house needs to be repaired or demolished or vacated or closed. And it'd be as the time of the date of that hearing. We're saying the same thing. I agree with you. It'd be as the time of the date of the hearing. For an appeal case, I want to be very clear on that distinction. If it's an appeal of an NOV, the question is the date the issuance of the NOV, does the evidence support the NOV?
But we're only talking how many days between an NOV being issued and an appeal coming before us.
In an efficient, perfect world, it would be your next hearing. You would hear those appeals. That's a lot of that has to do with docket time. There's some other factors. But again, let's say we got 90 days out before you could hear an appeal and the owner had made progress. That's great. The owner's made progress. Still, the question for you is, can we uphold that NOV as of the date the NOV was issued? That does not give the city at that point the authority to go on to private property. If the owner has made repairs, that's awesome. Then the owners continue to make repairs, and we may never get to the request for an ordinance for failure to comply. All you've done is confirmed that the inspector's NOV was a valid NOV. The property owner remains in control of the property and has the ability to repair and voluntarily live in the property.
But it's relatively rare that we receive an appeal of an NOV. Usually it's a request to uphold the inspector to issue an ordinance.
I agree that has been the practice. I think that's where you're going to see the change.
So I guess what I'm getting at is I'm trying to understand this change you're proposing.
Because the ordinance is only required if the city is able to act to effectuate the repair or the demolition. In other words, there's no reason to give an ordinance to demolish a house if it's just going to sit on the list if the city is not ready to demolish it. Either doesn't have the budget to demolish it, or it priority-wise, it's not a priority to be demolished.
So
how?
Well, I was just going to say, is there going to be a difference in, or are you suggesting that there will be more NOV appeal?
No, I'm not suggesting that, but so let's take a case where a property owner is continuing to work on a property. Past that case may have been brought to you for an ordinance to demolish because it was greater than 50% of the repairs. If the property owner is continuing to work on the property, and if it's not a priority for the city to demolish that property, or if the city doesn't have the budget to repair the property, or we don't have the grant program we've discussed, there's no need for an ordinance. The ordinance kicks in if the owner fails to repair, demolish, or vacate, and the city wants to effectuate repair, demolish, or vacate, then we need the ordinance. The property owner is working on it. The case is not going to come before you anyway. because they have not yet failed to do so.
But it would be up to the homeowner to raise the appeal of the NOV.
It'd be up to the homeowner, and a homeowner can raise an appeal of any order issued by an inspector, whether it's civil penalties, which you've seen, whether it's NOV, or whether it's, condemnation. They could appeal the issue to condemn. But most of the condemnations are, at this point, they're voluntary. The city can't force someone out by eviction without an ordinance.
So I guess what I'm getting at is we would not necessarily see an increase in appeals of NOVs because that would be dependent on, it's up to the homeowners to decide to
Correct.
appeal. In essence, what you're saying is the city is making a policy and procedure decision to bring less cases before us for upholding an ordinance.
I don't know that it's necessarily a change of policy. It's really, it's a change of not bringing cases unless the person has failed to comply and the city is able to act. That's the state law, that's the ordinance. And I think the practice, it's not really a policy, it's a practice. The cases were brought before you, even if there was not a failure. I've seen. So the cases that come before you now, we would have to show failure and cities' willingness. And if that's the case, then we would require an ordinance.
So in essence, this would be staff exercising more discretion about what cases are put before the commission.
Yeah, it'd be staff having to be able to substantiate the evidence that the owner has failed to comply.
So it'd be an inspector saying, well, if they're doing the work, but they're going slowly, I'm going to keep this from the commission for now and only put it in front of the commission if I feel they're not doing the work in an adequate manner and an adequate speed.
Yeah, so an inspector would bring a case to you if the inspector believes that the property owner has failed to comply. You would then have to make the decision, is there a failure to comply? Has the property owner done something? Is there some progress? And is that progress, does the evidence show that that's a failure to comply or it's just limited progress? That would be the issue for the commission before you even get to, is the city, willing to effectuate whatever it is?
So, and I guess that's not really a change on the commission level from our current procedures.
Correct.
Because a case comes before us and we say, if it's someone that we know has the ability to fix something and they're just sticking their head in the sand, we uphold pretty quickly. If it's someone who says, I don't have the money, we work with them. So that's not changing under this proposal.
Correct.
Okay.
So just to continue on the discussion rather than going through your memo, which I apologize for. What will we do with the cases that are already in our circulation?
I think that's what Director Blue was referring to when she said that we need to go back through the cases and look at the cases that are pending and determine, are there cases where property owners making progress? So, in that there is some discretion to what is progress, but are there cases where making progress? And if there's not a failure, then really not an issue for the commission to hear. So that case may simply come off your docket. If there is a case where there's a failure and there's a need to demolish or to repair, and the city is able to do so, then the city would prioritize that case to be brought back for the commission. In other words, so the cases that may come back up on your docket, if there's no point, I'm not sure it'd be a good use of your time to hear a case where the property owner is making progress just to have you review it. If there's no failure, then I think what we called in the past new cases, the new case isn't necessarily, doesn't need to be heard unless there's that failure of the property owner to comply.
So I think best in actual examples that I can recall from memory, we've had situations where a resident appears before us. They have most of their stuff done, and they come before us and say, like, hey, I just need like a week. I need 2 weeks. And oftentimes the inspector will confirm this. Yeah, they're looking great. Everything's going ahead and they gotta, they gotta put a nail over here and they have to paint this. And so we just say, okay, well, great. So are you saying is this a substantial change where in such cases now those folks won't even have to come before us because whatever the mechanism is, the inspector can say they're almost there. Let's not waste everybody's time by bringing it up before the commission. Is that what we're saying? Interim director, Lou's nodding her head, so I'll just take it as like,
Yes.
I mean, because I think we were just talking about efficiency and stuff.
Yeah,
I'd say, I guess I'm just guessing, it would save Troy a lot of time. It'd save the wonderful folks who put together these amazing binders of
Yes.
stuff. And it would save the commission's time to hear a case, which is for all intents and purposes 90%, 95% done, and the inspector, herself is actually saying, I've got every confidence this person has been on the ball. They got to do this paint job, they got to put this window in, and bam, it's done. So we'd be seeing fewer of those cases then,
Yes, we recognize that those cases make you all feel really good, but it's a lot of time and energy and work to prepare those cases to bring to the commission when they're going to resolve on their own anyway.
Right.
And for the record, I am very
Thanks.
much fine with only seeing the more difficult cases. Well, I love to hear people fixing stuff. Like, I think, the George Marples case that was on the agenda today, just for kind of informational purposes. Everyone on the commission here, I know that's been on the commission's docket for at least the last 5 years I've been here. We know he's doing work. If something happens and an inspector thinks otherwise, bring it before us. But for that type of case, there's no reason for us every couple months to say, yep, you're still doing good work. And it saves city staff a lot of time and energy of not having to prepare packets each time for that.
So looking at the state law and looking at our ordinances, in theory, what you'll see, if it's a request for an ordinance, there should be substantial evidence that there's a failure to act. And the greater weight of the evidence is there's a failure to act and the city needs to step in.
So we'd be looking at more cases like if, for instance, a landlord was not fixing electrical issues at an apartment complex and we knew they had the resources and that's a substantial fire hazard, that would be the type of case we would see.
I would think, yes.
Okay.
So, the question then that I have, I mean, this sounds wonderful. It'll be more efficient for everybody. It'll be certainly more efficient for the folks that come before us. And I know we're trying to get more funding for Troy to be able to do repairs and demolishing. But you said several times that we're talking about bringing things to us that the city would be able to go ahead and demolish or repair. So I'm thinking about the huge cases, the huge load that we always have of houses that are sitting there for years and years and years. Am I correct in assuming, I guess this would be really more asking Troy, that the cases then you'd be bringing to us would be maybe ones that are more serious, so there would be, there may be a danger to the community or somebody else, so that they would be up on the demolition list?
Well, the city wanting to act and the city being, the question of timing when the city can act is not clearly defined in statute. But where there's a failure and that can be proven to act and the city needs to do so, that property may still sit on a demolition list longer than anybody wants, but then it's a matter of prioritizing properties and prioritizing the budget to get to that property.
Right, always.
The ordinance then is an order in the chain of title that the property has to remain closed and vacated. So it's an extra tool in the chain of title, but as well as to protecting the public that the property is vacated and closed, even though the city may not be able to effectuate that demolition or repair in the timeline that the commission wants or the public wants or that the city wants. But it still gives the city the authority to effectuate that repair or demolition or order the property be vacated through summary ejectment.
Well, I can see that, and I can see that that would be useful. And I know all of the things we're trying to do to get things done faster and if a receivership program is done well. I mean, I know there are lots of other things, but that does come to my mind, and it always has, because we've always, since I've known anything about, before I knew actually what minimum housing was, I knew that we had big backlogs in the city of Greensboro for houses to be demolished. So,
And also, I think this makes sense. This is frankly different from my understanding of last meeting, and maybe I misunderstood, and I appreciate you clarifying. But basically, it sounds like what you're saying is the cases where they just need a touch more time and they're in good faith trying aren't going to come before us.
Not for an ordinance, they should not.
Okay. And the cases where an inspector has deemed that the owner has the ability to fix it, but is just not for whatever reason, those are the ones we're going to hear.
Yes. That's the game plan.
That makes sense to me. Yeah.
Yes.
that sounds great. I mean, it's efficiency, getting something done, action. I think you have a reputation from Winston, don't you? So I'd say thank you for bringing it on to Greensboro.
And it brings with, Commissioner Furman, you had a question about continuances. So continuances, the ordinance gives you the authority to continue cases that are on appeal, and you have to provide in your continuance the written reasons for continuing an appeal. And I'm hoping that when you put in perspective of an appeal versus asking for an ordinance, why the continuance may be limited. So if someone has appealed an NOV and all we're asking is to uphold the notice of violation as of the date that it was issued, and that we're not asking for the authority for the city to go onto the property, but really we're just upholding the NOV, clarifying for the property owner, these violations exist and you need to address them. That's all you're clarifying. When you consider that, the property owner is saying, I need more time to repair them. We understand you're going to get more time. The only reason that the NOV is before us, the appeal is before us, is to clarify that these violations exist so that it's very clearly defined for the property owner, here's what you need to repair.
Let me stop you right there. So are the NOVs coming before us because the property owner has requested an appeal of
Yes,
the
ma'am.
NOV? Okay, so somebody who has it and says, yes, this is all wrong and I get it and I'm working on it, they're not ever going to come before us as an NOV appeal.
No, someone, you may very well, if I understood your comment, someone who says they're wrong and I'm repairing it, if they're saying that the city is wrong, that's an appeal, if I understood you correctly.
Right. No, I meant, yes, my outlets are broken. Yes, my water is leaking, whatever, and I'm going to fix it. That's not going to come before us as an appeal in any way.
If they're acknowledging that, most likely they're not going to appeal the NOV. Now,
Right.
they may appeal the NOV just because they don't want the NOV to be in place and they're still repairing it. Understand that feeling, they don't want the NOV in place, but the question for the commission is there evidence to validate the NOV as of the date the NOV was issued? If they're making repairs, that's awesome. We'll never get to the requesting you for an ordinance, but we need that NOV to be verified so that the property owner knows specifically what needs to be repaired. And it clarifies for them what needs to be repaired because you have verified the notice of violation and that there's evidence to support the notice of violation.
Okay, but they're only going to come if that homeowner wants to appeal the NOV.
Correct.
Okay, That's
So-
what I just want to be real clear on.
Can I give an example just to, I want to make sure my understanding is crystal clear. So let's say, I'll pick on Mr. LaRue. If Mr. LaRue comes to my house and let's say my toilet flushes a little slow and he says, this is a major issue. This house is condemned due to plumbing issues. And I say, no, that's not like there's a plumbing leak. It's just a little thing. I, as the homeowner, could appeal saying he was wrong in finding a major issue. It's not a major issue that shouldn't have been issued.
Correct.
And the standard would be, let's go back to the date that he came to my house.
Correct.
Now, conversely, if a pipe bursts and my whole downstairs is flooded, that would be a major issue. And if he finds that and I say, yeah, I know that's a major issue, but I'm working on it, that would be an ordinance.
No.
That,
No.
okay.
So your first scenario, he says, I disagree, I'm appealing.
Or I, the homeowner, say, this is not a major plumbing issue, I'm appealing.
Mr. Eiskov says there's not a major issue, I'm appealing your NOV, comes for a hearing, and the question is, did Mr. LaRue have substantial evidence, greater weight of the evidence to prove that those violations existed?
And then we'd look at, I'd say, here's a video of the toilet. It's a
Sure.
really minor thing.
Yeah,
And-
and he would have his evidence, you may have your evidence, and then the commission, Mr. Isaacoff would have his evidence. The commission would have to determine greater weight of the evidence, who do we believe?
Mhm.
What evidence is more credible, and where do we uphold the NOV or do we uphold the appeal?
Mhm.
Um,
Now, let's say it is a major issue. Let's
Same. So your pipe is burst, your house is flooded, and you say, I don't like the NOV, pretty obvious it's a major issue. I'm still appealing your decision because I don't want the notice of violation to stand on my property.
then we would
And-
probably uphold as a commission.
Well, the same question comes before you as the date of the NOV,
Mhm.
with the evidence, greater weight of the evidence, verify the NOV. And the other difference is, as long as that case is on appeal, we can't issue a lis pendens to protect future property owners. So until that appeal is heard and until that NOV is upheld, the lis pendens doesn't go in the chain of title. So I'm gonna play devil's advocate because that's what attorneys do and it annoys people. But someone appeals, they have 60 days, and in that 60 days, they sell the property. And the appeal is continued because they say, I'm working on it, it's continued 90 days, 120 days. They're able to sell, new owner comes in, and there's nothing in the chain of title to have protected them from violations that were arguable violations, but not obvious, to the naked eye.
So theoretically, if I'm a homeowner, a reasonable homeowner, if my downstairs is flooded, I'd say, yeah, he's right. This is a major violation. I'm not going to appeal that.
Yeah, you're not gonna hear those cases.
But
chances
let's say I say I'm hiring contractors, I'm doing X, Y, and Z measures to fix it. Theoretically, the case would not come before the commission because I'd be in contact with Mr. LaRue and I'd say, here's when the contractors come in, here's what steps were taken. And he'd only push it up to the commission if maybe I weren't contacting him or I weren't moving forward with anything or.
Chances are that property owner that's making progress is not going to appeal the NOV.
Mhm.
The homeowner could. You've had cases come in where people have appealed and said, I am working on making the repairs. The purpose of the appeal is we appreciate that, but that's not the issue before you. The issue is, can we verify the NOV so that we can issue the lis pendens, protect the chain of title, and then the inspector has a little more authority to encourage those repairs to continue, because so long as the case remains in the appeal status, there is no encouragement or no ability to enforce the repairs.
Because in this hypothetical, if I'm dragging my feet, Mr. LaRue could say, sorry to be picking on you on this. He could say, look, you really need to get on this or else I'm going to have to kick it up to the commission.
Ask for an ordinance. An ordinance meaning that the city may then effectuate these repairs or demolish a house.
Okay, I think I understand.
Okay.
And I'm in agreement with that.
I don't think we've ever had a situation where we've continued an NOV appeal.
Doesn't sound like you've had many, so you may not.
Right.
I
So-
think that's been relatively rare that we have an actual appeal of
Right.
the notice of violation. Usually it's a,
And that
yeah, we
came-
know there's the violation, but.
Right.
And so then.
We've
so then-
also never, ever disagreed that the violations were there.
Mhm.
I don't think that's ever happened.
So then let's talk about continuing an ordinance case. Case is brought for you because the city wants an ordinance. The question is their failure to comply, and the city, does the city need to effectuate? If there is no failure to comply, meaning there's evidence of progress that disagrees with the city's evidence of failure to comply, and you don't think that the city has met its burden of failure to comply, then deny the case. There's no reason to leave it on your docket to continue it so that the person finishes the house, deny it. And if the city needs to rebring it to be reconsidered for failure to comply, the city will do so. Otherwise, there's no reason to leave it for you to monitor and get monthly updates on the case. The city has to meet its burden. If it does, enter the ordinance. If it doesn't, then don't enter the ordinance. And it's up to the city to bring, different evidence the next time it comes before you.
Now, and this is one point I want to hone regarding our standard, because I was looking at the ordinance and basically it says the commission shall have the power in passing upon appeals in any case where there are practical difficulties or unnecessary hardships in the way of carrying out the strict letter of the housing code. That's our authorizing local ordinance. So some cases come before us where an inspector might say, I need to kick this up to the commission, rightfully so, and there are violations. But for whatever reason, and common reasons we see are if it's air property, or if it's just inability to pay for the repairs, or a landlord who dragged their feet but now realizes they're getting in hot water, we do have some discretionary authority to continue the case, to work with the homeowner to keep that supervisory authority.
So I want to go back to what you said at the beginning of the comment. The inspector kicks the case up to the commission.
Mhm.
The inspector's only kicking the case, using your phrase, up to the commission when the inspector wants an ordinance.
Mhm.
In an appeal case, you have in the language in the ordinance, if you look, is in the section of appeals. You have the authority to continue appeals under some circumstances, and you have to state those circumstances. So I want to distinguish between an appeal and asking for an ordinance.
Mhm.
If the inspector is asking for an ordinance for failure to comply, if the inspector cannot substantiate the failure to comply, then there's no reason to continue the case, deny the ordinance. And then the case comes off your docket. It's up to the inspector to bring the case back again to prove failure to comply based upon new evidence and more time has passed to again ask you for an ordinance. So I think the confusion is that we're using language in the appeal section to continue with continuing a request for an ordinance. And my point is there's no reason to continue a request for an ordinance because if the city can't meet the burden, you simply deny the request. There's no reason to keep that case on your docket.
Doesn't that create a huge bureaucratic workload though, to start a case over as opposed to just continuing it?
It imposes upon the city to have their evidence when they bring it to you.
I agree with that, but I guess what I'm thinking of, without naming names, there's certain landlords that I could see a situation where it comes before us and we, for whatever reason, we don't think it's there to uphold, but we think there's work to be done. And it would make sense in terms of time and efficiency in getting stuff done to keep it in front of us and continue it.
If you say there's work to be done, that's up to the inspector to monitor, is the work being done?
Mhm.
If it's not being done, bring it back to the commission. And again, request the ordinance. And the evidence would be, the last hearing, you said A, B, and C needed to be done. A, B, and C has not been done. X days have passed. Again, this is a failure to comply, and there'd be a new request. Putting what I'm trying to encourage is not putting it on your docket to where you have cases that have to be reviewed on your docket, because that takes up time for cases where the city may really need an ordinance on this property. And we're trying to avoid those review cases where.
And I wholeheartedly agree with
Yeah.
that, with taking off the cases where we're just saying,
So the ordinance gives you the authority to continue appeal cases. The
Mhm.
ordinance does not give you the authority to continue ordinance requests. And I think the reason being that you simply don't grant the ordinance and the case comes off your docket and the city represents it.
and I guess I'm looking at it from a policy perspective of, does that rule make sense for every single case?
It may not, again, we get wiser as we go. So there may be a situation where that's not the case. We'll deal with that as it comes up. And there may be a case where we all agree, continue it. There may be a case where you hear from staff or from me simply saying, deny the ordinance, we'll come back when we're ready.
And I guess, so here's what I'm getting at. We have teeth as a commission to take action against property owners who might have less than ideal intentions. You know, we see some property owners who are trying to dodge having to pay for repairs and will do the minimum required to get by. So if we kick those cases back and say, start over.
No, we're not, I apologize. Thank you. We're not starting over. There's still a valid NOV in place. There's still penalties that are accruing. There's no starting over.
So the case is not closed.
The case is not closed in the
Okay.
least. We've just asked for an ordinance on failure to comply, and you've either granted the ordinance or have denied the ordinance. The case remains open until there's compliance.
So in a situation where it's a landlord tenant property, my concern is I don't want to have tenants being left kind of in limbo while this is going back and forth between an inspector and the commission. I want it to be fixed as quickly as possible.
And I think everybody does. And so, the question there is, has the landlord failed to comply? And if the inspector has that evidence, the inspector is going to bring it to you for an ordinance so that the city has the authority under the state law to do so.
So if it's a landlord who we say, yeah, you've got the money to fix this, we agree with the inspector that you're just not doing it, we would uphold.
You would uphold the ordinance, yes.
Which that has been our practice in the past when we've thought that. And you're saying basically we would see less of the cases that we would typically continue.
To make sure they're complying or make sure they're continuing to comply. Those are the cases you.
Because those just wouldn't be brought before us.
Correct. We're seeing progress. There's no point getting an ordinance. There's no reason to bring that case to you.
Okay.
And I'm going to, there was legal questions and I know I dipped into policy, but all right, Director Blue said I'm still good and she's not kicked me under the table. So I just want to make sure that we are on the same page and, but that's why the continuances, and I'm sorry it's taken me 3 meetings to better articulate this. They don't call it practicing law for no reason, but there really is no reason to continue an ordinance case. Uphold the ordinance, don't uphold the ordinance. It does not close the case.
And I guess the issue
In
is
the
when that
past.
was brought up originally, we were thinking, well, let's look at the cases we're currently handling. It makes sense to continue the cases we're currently handling.
I understand.
But what you're saying is we're just not going to see those cases. So is there a legitimate reason that we would, in your mind, that we would ever continue an ordinance case at the commission level?
Sure, I'm sure it could happen. I think someone's, within 15 days of finishing, but it's already on the docket. Chances are I would think that staff would pull that case before it gets to you anyway, not to bother you with the motion to continue. But could there be a situation where, I'm sure there could be a situation, we just have to take it as it goes. In my mind, and I may be oversimplifying it, since we're not closing the case and since we are not reinventing each case. If you disagreed at that point with issuing the ordinance, it would be denied, and the inspector would hear your reasons why and could better develop the evidence next time it comes before you.
And that's good to hear, because what I want to make clear in my mind, each of us were put on this commission because we have some experience, knowledge relative to this, some discretionary authority to say, yes, here's the strict letter of the law, but then we hear the individual facts of every case and we weigh that and we make a decision based on that. So I want to make sure you're not saying that we don't have that discretionary authority. You're saying the cases that'll come before us will be more clear cut because we're taking away a lot of those cases that merit an analysis of the equities.
In theory, yes. I mean, the discretion is for the commission to determine, has the city met its burden according to the statute by greater weight of the evidence? That's your discretion. If the city hasn't, what I think I'm encouraging the commission to do is, instead of keeping that case on your docket, deny the ordinance and let the city come back and represent it when the city has better evidence to present to you. There's no reason.
And denying the ordinance would not mean denying that there's violations. It would be denying that denying the inspector's statement that there's a failure to comply.
Yes, sir.
Okay.
Correct. At that point, the order is, the NOV is valid. Either it's been appealed and upheld, or it was never appealed, and as a matter of law, it's then valid.
But the violation order would still stay in effect even if we
The
deny.
NOV is the violation order. The violation order at that point, before we'd ask for an ordinance, as a matter of law, is in effect and is not being questioned. And so just to make sure I'm clear, we talk about continuing an appeal. As long as that NOV is in an appeal state, then we cannot issue a list pendants, and civil penalties cannot start to accrue. So the encouraging tools that the commission and the city has and the state law allows us don't take effect as long as an appeal is in a continued state. We want to have that heard. And the simple question is should the NOV be upheld based upon the evidence at the time the NOV was heard? And again, the property owner remains in control of the property at that point. Their ability to repair is well within their hands because they're still in the property. It's only when the city is asking, and here's the due process for the property owner. It's only when the city is asking for the ability to go onto private property to either vacate, demolish, or repair, do we need an ordinance. So you hear, we had a case not too long ago where the property had been condemned. And there was, rightly so, because we're all human, did the family have a place to go? My understanding, and I'm going to ask Director Blue and Mr. Powell, my understanding is that the city, without an ordinance, cannot force someone to leave the property without an ordinance, but they generally get voluntary compliance by helping to find suitable housing or other housing.
Though my understanding is from the moment the violation report is issued, it's deemed uninhabitable and people should not be living there. Is that?
Yes, but there is some discretion to order the property to be vacated by the inspector.
Okay.
And the inspector can order the property to be vacated and can obtain voluntary compliance.
But to use basically state force to do that, you need the ordinance.
We need the ordinance, and then we need summary adjustment. My understanding of the 160D, the new.
You do a writ of possession and.
Yeah. So yes, to effectuate putting someone out, you would need the ordinance, but you can obtain voluntary compliance. And there's still the criminal penalty if you violate the inspector's order. Don't know how often that is used, but the criminal penalty.
Trespass or.
Well, it's a misdemeanor. Whether that's effective on really keeping someone out of the property or not without an ordinance. I don't know that we've used that as a tool. Generally, finding someone other housing helps secure the condemnation of the property.
I don't think there's ever going to be a time we don't have that discussion when those sorts of cases come before us. Like, I remember there was another case, there was a lot of animals involved and we upheld the inspector at that time too. And it was the right thing to do, but we still didn't, we were all in agreement. We were going to uphold the inspector, but we waited for, the right other people to be, they were all in the room. We did not continue the case. We went ahead and upheld, but there are occasions where it's really necessary, but we're still going to have a discussion over, the care and well-being of the people. So
Mr. Begg.
can I ask you, I just want to see if these two cases from the past would come before us, just as examples, just so I have a better understanding of what is going to change. Westridge Road, I think that was yours, wasn't it, Jeff?
Microphone, please.
Make sure you're on.
Yeah, my apologies. I was not the inspector there, but I'm familiar with the case. It was Inspector Rustin's case where the owner would come before you on a regular basis, showing that repairs were actively being made there. We got an update every month or two until completion of those repairs were made finally by the owner some months down the road.
So would that case come before us today with these new?
Based on what
changes?
I'm hearing from Tony, if the owner is showing the intent to make repairs, has made repairs up to that point, no. Just based on what I'm hearing here today, that sounds like something that we would not be bringing to you if the owner is there actively making repairs. It sounds like we would be bringing stuff to you where the owner is not actively making repairs and has no intent to make repairs or something to that effect.
Okay, so here's my second case. Muir's Chapel. That was an older house that was on two properties and there was a lot of family issues.
I think it was Dolly Madison.
I remember that.
Dolly
one.
Madison, that's right. Yes, Dolly Madison, you're right. They're parallel right there. And there was a lot of issues, and I feel like we gave that family an enormous amount of leeway to figure out what was going on.
Because there was a legal battle about
There
that,
was
right?
Yeah,
And-
it was crazy. So, but we finally said enough is enough, and we upheld the inspector, and the family ended up demolishing the house, which was actually really sad. That was a beautiful house. But would that have come? That would have come before us, but we wouldn't have had that leeway. What you're saying now is we wouldn't have that leeway to give the family time to sort out their mess.
I can do some research into what does failure to comply. Is it just factual time has passed and you haven't done it? But I think where you have the discretion is, does a greater weight of the evidence show a failure to comply? Intent, refusal to comply.
And I think what Ms. Lamoth is getting at is sometimes there's reasons for non-compliance that are not just the homeowner putting their head in the sand. Like this one, I remember it was two sides of the family and they had lawyers, and we've had a couple of those cases where they're not fixing it, but it's not due to the fact that they don't have money. It's due to the fact that they're duking it out over some legal issue. And
They
it
even
really
tried
doesn't
to-
make sense for us because I think we had that for like a year, and Barbara Washington was the lawyer.
Yep.
And she would come before us and say, we're figuring it out in court. And we'd say, all right, well, we'll continue court proceedings. And I don't personally think we really needed to hear it at that level.
And vandalism, they had vandalism.
Vandalism, yeah.
Mhm.
And there was the property by the IRC where there was,
Yeah,
there were
that too.
two family members fighting, or I think three family members on that one.
So what you're describing, what I heard you say is there was an ongoing court case where they're trying to resolve issues, and that court case was affecting their ability to comply with the order.
Because none of the heirs wanted to fix it until they had clear ownership.
So I think where the discretion comes in is based upon the totality of the evidence that you hear, is there a failure to comply? And what I heard you say was there's an ongoing court fight. There was an attorney. So in theory, money being spent to try and resolve the issue before repairs could be made.
Mhm.
I could see where the commission would determine that's not a failure to comply. That's a legal issue that's standing before the ability. So again, that case comes before you. You vote and determine that greater weight of the evidence, there's not a failure to comply. Again, going back to the point that I'm making, don't continue it. Just deny the ordinance.
And then the violation is still in place. And if the inspector says, okay, another couple months have gone by, nothing's happening, he could bring it back to us.
Now, in another couple of months, the case has been resolved. The
Mhm.
property owners, the heirs took the money and they've left town. Different
that's an
case,
issue.
different facts. Maybe then that's a failure to comply. And the attorney doesn't show back up at the next hearing.
Mhm.
Those are different facts that may then convince you by the greater weight of the evidence, there's a failure to comply.
Okay.
But there wouldn't be the need to continue it, to keep it, to monitor it. And again, yeah, hopefully the case that you get, these cases you get for ordinance, instead of we need an ordinance now to put it on the list, we need an ordinance when there's a failure to comply and the city wants the ability to go into private property, and your job to protect the property owner's due process is to make sure that the evidence shows there's a failure to comply and that these violations still exist at the time of the hearing.
And eventually, if there were, let's say, a prolonged estate dispute, most of the legal disputes we see are siblings fighting over, property after mom and dad died. So if there were that, we could give some leeway and say we're gonna deny based on the fact that there's this legal case. But if it goes, let's say, 2 years, and we say, look, we can't have this property sitting dilapidated for years on end, we could eventually, if the inspector kicks it back up to us, say, all right, we've given you enough time to resolve the legal issue, we're going to uphold.
Yeah, if you're asking me, is that within the authority under the statute?
Yes.
Yes, based upon the evidence presented, that hypothetical could come to pass where you could say now the greater weight of the evidence is that there is a failure to comply.
Because it's been X many years.
And that's the beauty of the democratic process and the votes and having to have a majority and all of you individually hearing the evidence. And as I guess say the jury process, because in that point you would be to some extent the jury hearing that evidence and making a decision. And if the majority of you were convinced, then there would be a failure to comply and the ordinance would be issued.
Okay.
So I want to make sure, Commissioner Furman, you specifically asked about continuances. Does that help with better understanding? And I don't think I very clearly explained when to continue and not to continue, but does that help with the perspective from the city attorney's office of when the commission should consider continuing and not consider continuing?
Yes, it does. It does. And when the cases start coming before us that fit this mold, I feel totally comfortable going with it and doing these things. I do have one question though. Can you just lead me, because I'm a little bit of a policy wonk. I would really like to be able to read this if it's in state statute or a city ordinance where item C is in the state or in the city ordinance.
It is 160D-1203.
Okay.
And I'm happy to send that to you. I'll email it to you with the memo. And it's 160D-1203 subsection or subdivision 4 specifically.
And that's in our local ordinances.
No, I'm saying state statute.
Oh, general statute. Okay.
General statute.
GA.
If you would send that to all of us.
Oh, I
that'd
will.
be
If I
great.
send it to one, I'm going to send it to all. Absolutely.
Thank you.
Yes, ma'am.
Thank you.
And so what you'll find in that state statute is that basically there is the first provision says that the order's in effect. And the property owner, the inspector may order repairs, order demolition, order the property to be vacated. If the property owner fails, refuses to comply, then the inspector may add that subdivision 4. The inspector may request an ordinance so that the city can effectuate the repair, demolition, or vacation and closing of the property, which generally means summary ejectment. And then there's another due process protection process we're going through to have the person evicted.
Thank you very much. I really appreciate it.
Oh, yes, ma'am.
Well, is there any further discussion? I don't know if this needs, I don't think there's a vote that needs to be taken. I really appreciate the clarification on this.
Mr. Powell made a point that I didn't mention that I want to make clear. So you could have a case that comes before you on an NOV appeal. The NOV is upheld, and some period of time later, that same case comes before you for an ordinance. That point being, the inspector has evidence that the person has failed to comply. So you could see the same piece of property twice. And the question being at different times, NOV, date of issuance, ordinance, date of hearing.
Because for an NOV case, an NOV appeal, we're not deciding whether or not to repair or demolish. We're deciding whether or not there are violations.
Yes, thank you.
Okay.
Very well stated. Now, property owner is under an order to repair, demolish by upholding the NOV, but we're not deciding at the NOV appeal stage that the city can effectuate the repair or demolition.
We're basically backing up the inspector saying, yeah, the inspector's right.
The inspector's order is correct.
And we can do a better job in clarifying that with the agenda as to what decision, whether this is a fail to comply decision we're looking at, or whether this is upholding the inspector. But one of the things not to confuse is we've always said upholding the inspector adopts an ordinance. But one of the things I had mentioned to Mr. Baker is that if the appeal at the very onset is appealed and it comes to you to review the NOV of either a nuisance violation or in order to repair and a housing violation, if you see also based on the evidence that the inspector sees that, yes, this is correct, then what's going to happen is you simply agree, yes, this is correct, we uphold it, but it's going to go back and start at our enforcement stage. The appeal stops all enforcement. And that's the reason why Mr. Baker had said earlier that if you continue that appeal, understand absolutely no enforcement's happening because that inspector has set it aside. The ordinance requires them to set it aside and not do anything else to that case until it's determined whether or not the inspector is actually correct. So then it backs up, and then the inspector is allowed to work with the owner, document the case, and move the case forward. And somewhere down the road, after the inspector's extensions, rehab extensions, director extensions, if the owner has failed to comply and the inspector can prove that, and it comes to your docket, then you may see that same case one more time.
And I think it would make sense on the dockets in the future to specify whether it's an NOV appeal or issue the ordinance. Because in my mind, what we're saying is there's two different standards, and I could see myself making different decisions on a property based on whether it's to uphold the NOV or to issue an ordinance to
No,
repair or
absolutely.
demolish.
And I think what you've seen on your agenda in the past is new cases. I'm using air quotes, new cases. I don't think you'll see that phrase anymore.
Mhm.
I think it'll be very clear. These are, I think, just thinking out loud, we have civil penalty appeals. So it may be a title of civil penalty appeals. It may be NOV appeals, and then it may be request for ordinance to repair, demolish, or vacate. So you may see those headings. So it's very clear why the case is there before you.
That would be great because that spells out the standard of review that we're supposed to apply. And I think right now we apply a uniform standard of review. And what you're saying, and I think it's rightfully so, is depending on the case, we have to apply different standards of review. So I don't think that requires a vote or anything. I think this was a very good clarification, and I really appreciate the memo and our conversation.
Absolutely. And you can throw away the memo that I gave you because I'm going to send out a slightly edited version. But I'll email that along with the statute so that you all have a copy, and I appreciate your patience.
May I ask one question from Troy? We should be seeing more commercial properties coming through. Is that, or do you have those, or has that changed? That process changed?
You're talking about non-residential
Right.
for the good repair ordinance?
Right.
I don't know of any that you would see coming to this commission, except if a business appeals the inspector's findings from their administrative hearing. there's not any commercial properties that is currently has funding for repair or demolition. Because obviously the commercial properties is much greater, cost a lot more. So there's not any, we have no active non-residential cases that are traveling the path that we're going to be asking for an ordinance. Most of our non-residentials, we've opened them, they've complied, and we've put them on the 2-year cycle. The city ordinance for good repair requires that as long as the structure remains vacant, and no employee or no public has access to it, they fixed all the exterior violations and then lock it down. And if they do so, then the structure, they do not have to comply with the interior violations for 2 years. So we have to make that case inactive. And then at the 2-year mark, we reinspect the structure. If they have not already effectuated the minor violations inside the structure, that's when they actually violate the ordinance. So the non-residential code has a couple different standards. It's a little complicated, but we made a little map for it when it was first adopted, and but it's treated differently than residential, because residential, you can easily move into the structure. And you can easily rent it to move someone in, as opposed to a commercial structure. They can easily secure it and not allow public access.
And when is that 2-year time period coming?
Whenever that particular case. So if we opened up a case today and the inspector held their administrative hearing, issued the order to repair, and then the inspector worked with that property owner, told them what they needed to do. They fixed the outside of the structure, and the structure is now locked down, and that's what they choose to do. It would start from that day of lockdown. Once the exterior violations are effectuated. There's a property up on Cornwallis. I don't know the exact address, but there's a little shopping center that has a Pita Delight in it. There's a restaurant that's right on Cornwallis in front of it. It used to have those red awnings on it. All right. Yes. All right. So that one, if you notice, that property used to look so run down, busted windows, grown up grass, awnings all messed up. That was one of the first non-residential cases that we had for good repair. All of that was cleaned up. Everything was rectified. The inside of the building was made safe. All the outside violations were repaired, and they chose to board the structure up. So in boarding that structure up, that structure is currently sitting under a 2-year time period in that case. So we have that case as listed as inactive with a 2-year reminder that the owner essentially has 2 years to fix the commercial property on the inside. They can't have any violations on the outside. But on the inside of the structure, they have 2 years to either sell it, fix it, or do something. But once the 2 years is up, penalties are going to start, and then it'll start running down the enforcement line. And that's just the way the good repair ordinance was created.
Just a really quick question, and also thanks about the update of that place, because I walk by there all the time. It's in my neighborhood. Last session, we had 4 of these appeals, that were on the docket. And I think prior to that, there was something that appeared as an appeal in April, which was in the middle of COVID. I don't think we ever actually heard that, but, and then prior to that, in my time here, we never had any appeals. So we never heard any of these appeals. So is there an explanation as to why suddenly these appeals, we had 4 last time, and prior to that, basically very few or none in the recent past?
All of the appeals, nobody consented to virtual. So basically all the appeals that were happening at the beginning of COVID, we've had to put them on a list. Admin has maintained them on the list for the next, whenever the commission is back in person. And so now we've started to put them on your docket. one of the things that has occurred with some of those appeals is the cases has been brought into compliance. Because the inspector has continued to work with them. And it's like they wanted some distance and time. So one case on Oakland Avenue that was sent for you, that case was withdrawn by the property owner. There's some other, I'll check the list.
Yeah, no, I mean, like, I think you explained it already, that because of COVID, that's explanation. So I appreciate it. I just, like, we suddenly got these 4 cases. I don't think we've been really used to seeing these appeals at all or handling them. And our chairman was saying, the standard that we understood was just one standard. But I appreciate that. Thanks. That makes a
You're
lot of
not
sense.
seeing, everybody's not all of a sudden started appealing. They've been accumulating for 1.5 years now.
Well, is there any further discussion among the commission? I want to say I very much, both from Ms. Blue and from our city attorney and all the staff, I really appreciate the clarification on all those matters.
And just to notify the commission, the August meeting will be full in person. There will be no Zoom. So we'll be advertising it as everyone's permitted to be in chambers, and they will have to follow the any city rules that's in place for this facility. And those, as far as the only rules that would apply, is that the city manager's office has put out that if you are vaccinated, you're not required to wear a mask. If you are not, you're suggested to wear a mask and remain socially distant. But it's on your honor. You're not going to be required to prove that you've been vaccinated, and no one is going to ask you. It's just going to be assumed that if you're not wearing a mask.
Wonderful. We're getting back to normal. Well, I think that concludes all our business today. I'll make a motion to adjourn. Is there a second? Ms. Lamoth, all those in favor? Aye. That passes unanimously. We are adjourned.